This matter was directed to be listed yesterday, that it has not been yet listed.
Are they gone?
I was wait.
Pass on the memos. Let us see.
There is a stay order. 400 people have been prevented to enter their houses. That's why I.
Houses.
Yes, there is a dispute between the builder and the allottees. So LPA has been filed, which is not maintainable against MSA orders.
Whatever.
That's tender matter.
Tender matter is before us. Pass on the memos, ma'am. We'll see to it. Don't worry.
That's fine. You mentioned a matter. In this matter, let us be the contempt matter.
A bit louder.
My lord's, the contempt matter, personal appearance of the officer has been directed. My lord's requesting for the listing of the rate of
There must be a date fixed for that.
7th May, my lord.
7th May, they will come.
My lord's, the rate of appeal, my lords.
So what? In the rate appeal, the personal appearance.
Single judge has directed personal
Oh,
appearance.
then.
Against that, you have come against the judgment of single.
See, the rate of appeal.
Yeah, rate appeal. Say so. You say personal appearance. I was just thinking.
Oh. PL matter. The minor minerals illegal operation of the Parliament is concerning the demissing of office of the ORERA, which is the adjudicating authority, which is not 6 months. The entire functioning of the authority is going to be different minutes after 2nd of May. Because
Pass on the memos. See to it. Madam, write some urgency there. Don't worry.
in this case, 33. The respondent retirement date is good.
Okay.
For months.
Just
Don't
worry. Don't worry. That's a very honorable day. Don't worry.
In this case, common government challenge, this is the third memo, now the government intending to disengage.
Why it is a third memo? Why don't you list it? We'll go fast. Don't worry.
3 cases are at. Because they are disengaged, they are already passed a common order to disengage.
As a common order is a dangerous order. We'll see to it.
Otherwise,
So-
we know where.
Yes, let us see.
I have finally.
Sir, we'll definitely try. Don't worry.
Supplementary list item number 1.
This matter was yesterday. We have succeeded to tribunal. The appeal filed by the department is last. Now, your lordship have said that the assistant commissioner of income tax exemption.
Oh, that was there. That
Yes,
after this, how can he revise it?
Your lordship will also kindly see order dated 24/4/2025 passed by your lordship.
Have you taken instructions, sir?
Yes, Lords. Lords, my instruction is now they want to already they have issued attachment in all banks, Lords, for 23.
Yes.
No,
Mr. Sahu, we have asked you whether you will maintain in one of the banks the amount of demand, and beyond that, the entire demand is, he is not asking you to
No, I
charge
pay mirrors.
only 20% or
No,
whatever.
I want to pay mirrors.
Huh.
One thing mirrors. Only I want two mirrors, brief or also produce mirrors. Mirrors, in case of cases where assessee has already been granted an exemption, like the present case, there is adjudication by the also kindly keep in mind for with all the humility mirrors. Already there is an adjudication by the honorable tribunal holding that I am entitled to exemption. Mirrors in respect of what? In respect of the receipts mirrors, which the institution gets mirrors. What they have done, supposing out of 100 is the entire receipt which I have got mirrors, they say 5 rupees cannot be said to be application of income because the depreciation which you have claimed, that is not allowable under section 11(6), which is out of issue mirrors, not arising from anything.
Mr. Sahu, we are only on the point whether you will maintain this amount which is portion of the entire demand. Your first appeal is pending. During that, whether you will maintain in one of the bank accounts this amount or not. This is the only instruction we have heard yesterday.
But now my reply to Lordship's query will be that I have now have the instruction rush. Because in all banks, bank wise, Lordship will find what is the position. Many banks I find there is a lack of reconciliation between the attached accounts and the list. I am giving the entire bank account.
Yes.
Lordship kindly see bank balance as on 29/4/2025.
Yes.
Your Lordship will kindly see serial number 3. Serial number 3 belongs.
Yes.
So serial number 3, 88 rupees.
Yes.
Just a minute. You will kindly bear with me. It will be better if your Lordship kindly refer to the email covering all the banks.
Whatever. This is an Axis Bank account you are talking about. This is 88.
88.
So
your Lordship will kindly turn to
it's a dormant.
page 79 of the brief. It will be very clear. I will reconcile with this mirror. Page 79.
No, what do you want actually?
I want to tell by Lordship mirrors. The account details which are there issued by the Assistant Commissioner. But out of that, in one account there is 80 rupees, another account PNB 400, in other account 1,04,000, PNB 1,47, other account 400. Second thing, what I want to propose for Lordship, the attached bank account will yield only 2 lakhs of odd. But there are some fixed deposit liens also, and those liens total aggregate to 78 lakhs.
Correct.
And if your Lordship allow the department to continue lien of 2 accounts, that will be sufficient for the amount they have.
They wanted the security of their money.
Correct, Vilas.
The claim. Now, if the amount can be secured either by attaching or freezing one account or a multiple accounts, there's no difficulty.
Yes.
If you can show that this is a sufficient balance in this account, which will definitely cater your demand, no difficulty. They will be agreeing. No problem. Why? They are concerned with the money, nothing more than that.
Correct. Now the Lordship can see the other.
So the only thing is whether the exemption is allowable, whether you are entitled to exemption, whether the depreciation which you have claimed is justified within the purview of those act, is the matter which should be decided in your appeal because you have gone there.
Today is the date of appeal hearing there.
Correct. So you go and convince that. I'm sure that the person of your stature and knowledge will definitely convince him. You go and convince him.
They have counsel there. No difficulty.
No. Your services, why they will be deprived of? Let them. So this amount, the total amount, that would remain so far as your demands are concerned. 20% or 10%. How much? 20%. That would remain.
Like they have quantified also.
They have quantified.
Yes.
This quantified amount would remain freezed. Appeal is there. Let it be decided. And then the rest of the amount or any amount above that particular amount, there is no difficulty. He must be permitted to operate. You can't. That's a kind of a civil death.
Correct, absolutely correct.
That he can't operate, he cannot utilize money in excess of what your demand is. You can't
So, Virat,
put him in that position. That's the only thing. I think you not have to go into.
so the fixed deposit details.
This chart,
Yes.
first page,
Ah.
first item and fourth item.
Yes, two will be sufficient.
That will be sufficient.
Correct, correct. Anyway, those two will be sufficient.
First item means this one.
14.
Closing FD about as the 21
25.
Ah.
No difficulty. Your demand is how much? 23.
Like it is more than 26 lakhs. 14 lakh 63, 11 lakh 50. It is above 26 lakhs.
That will be kept secured
Correct.
till appeal is disposed of.
Yes. And
And
all other
other-
be released, withdrawn.
And withdrawn, and beyond this amount.
Challenging the order of attachment. Correct.
Only in respect to these two below, sufficient.
Which one is the annexure?
14.
And if even too late, you are also, as per your also direction.
No, which is the subject matter of challenge? Yes, sir.
Because annexure at page 70,
Yes.
11 and 14 below.
So total amount is 23 lakhs 26,600.
Right.
That's all?
Yes.
That's the quantified amount.
25. Correct.
Correct. Sure. That is what we.
Understand?
The subject matter of challenge in the instant writ petition is the notice issued by the department under section 226 within bracket 3 of the Income Tax Act 1961, whereby and whereunder the accounts held by the writ petitioner with several banks were freezed, obviously in contemplation to recover and or realize the amount quantified in the said notice. Shorn of unnecessary details, the proceeding was initiated by the department against the petitioner upon disallowing certain depreciation which it claimed as a organization who avails the benefit of the provision of exemption provided under section 11 of the said act.
Correct.
Stop. The proceeding ended at the domain of the assessing officer, and the order is sealed by the writ petitioner before the appellate authority. Stop. Undeniably, the said appeal is pending, meaning thereby the final adjudication has not been taken as of now. Amidst the pendency of the aforesaid proceedings, the notice of attachment to recover the 20% of the total demand is issued, which according to the writ petitioner is in excess of the powers conferred upon the authorities. Look, it is a specific stand of the writ petitioner that
Nullity. You are not saying.
yes.
One line on nullity. You have also observed in the previous order, my lord.
What?
About nullity, because these
No,
are
sir.
post effect of nullity.
I was going to dictate it.
Absolutely. Fine.
It is a specific stand taken by the writ petitioner in the instant writ petition that the assistant commissioner
Yes.
lacks complete jurisdiction and powers to adjudicate adjudicate upon the assessment order, which is per se illegal, which is illegal, akin to a nullity. We do not venture to to enter into such arena as the statutory appeal filed by the petitioner is pending before the appellate authority, and all such plea which is either raised in the instant writ petition or otherwise available both on facts and law, if agitated before the appellate authority, shall be considered and decided on its merit. We restrict our consideration in the instant writ petition on the amount of demand quantified in the said notice, and whether such quantified amount can be sufficiently protected by modifying the modifying the notice, by interfering with the steps having taken by the department in freezing all the bank accounts of the writ petitioner. We have been given a chart in course of the hearing at the behest of the petitioner, indicating the amount available in a different bank accounts maintained by the writ petitioner in several banks. It admits no ambiguity in law that the authority cannot proceed to take actions in excess of the demand by freezing all the bank accounts. The demand is already quantified in the said notice, and therefore it is inconceivable that the authorities would attach the bank accounts which contain the balance much above the quantified amount covered under the said notice. We have given to understand that two bank accounts where the fixed deposits are maintained would scatter the said quantified amount demanded under in the said notice, and therefore there is no justification in attaching or freezing the operation of the other bank accounts. What is that? We found that the fixed deposit with the Union Bank of India / Andhra Bank, the details whereof is provided in the said chart, has a fixed deposit covering more than the quantified amount demanded in the said notice. The fixed deposit in which bank you have held, this 11,58,000 and the 14,54,000. Which account?
Union Bank.
Union Bank.
Both the Union Bank.
Yes.
Stop.
Union.
But what is the account number?
Serial number 104. Serial number 104. FD number.
No, this is the fixed deposit number. Must be there in attached to any saving bank or a current bank account.
No, these are not
Independent?
Fifth column, bank account number.
No. That is fixed deposit bank account number.
that is FD number.
FD number.
FD number
bank
is a
account
different.
number.
Sir, madam, FD number is different. FD is opened, which must be linked to any saving bank account or a current bank account.
We have
What she's saying, there are two numbers. One is FD number
Column number 3 and 5.
and the other one is corresponding bank account number. I believe so.
No, this is the third column is a FD number.
Yes,
And
And then the bank account number is again an FD number. So that is why it creates a confusion.
bank account
hyphen FT number. So the two numbers are
Or
different.
this FD is attached to this
Yes,
bank.
sir.
That is good. You are just specify the number, that will be clear.
No, in Union Bank, you must be having one account which is.
No, there may be two accounts.
There cannot be, there cannot be 5 to 6 accounts. Madam, fixed deposit may have distinct number, but that is to be attached to one bank account.
Actually, Union Bank, they have several bank accounts and several branches.
Several branches.
But perhaps because of that, this is happening.
Yes, that
That may happen, yes.
that's possible. We understand. So, but you have not identified this 11,58,000 is which Union Bank branch?
In course of the day, you're not very.
In course of the day. Union Bank, you have given a second page. I do not find Union Bank. Yes. Just 1112. Oh, yes, I got it. This is 1112.
IRC.
You have already closed on 28/10/2022, madam.
Yes.
Yes.
You have closed it. What are you doing?
Two are closed.
And then how the FDs are held there?
The FT is something, and my instruction is that it is also auto renewed, your lordship.
And the second account amount, the account is, you have also closed it on 28/10/2022, both. These were there in the IRC village, BBSR.
Four accounts closed.
No, that I have seen,
No,
but
they are
these
not-
two accounts, FDs are, you are mentioning, but these two accounts are closed. Have you seen that?
I did not do. I'm sorry.
These two accounts,
Yes, yes.
these are closed.
The closed account, so why have you missed?
How the FDs remained?
When the FD are varied, certainly accounts cannot allow to be closed. It is supposed to remain
Madam,
alive.
you have, sir, you have shown that.
I have shown
Closed
that.
on 28/10/22, closed on 28/10/22.
I have brought you the position, correlate the fixed deposit with the corresponding bank account number. That's the difficulty. Huh?
Lakshmi, one humble submission.
Let us see if it is an independent FD. There is no difficulty. One can. In the bank, they can open an FD only without any saving bank account. It is not impermissible in law. There's no difficulty. So we are giving this FD number to be attached.
Yes.
That's all. And if there is a wrong disclosure made by them, inform us. We'll take action.
These two numbers should also be kindly mentioned.
We are mentioning, don't worry, we are
After
mentioning.
launch, I will mention
Whatever.
But it just for confirmation.
How they deposit with the Union Bank of India and Andhra Bank? The
Andhra Bank, under the FD number 14961 303 0000281. You just take down from this one, these two. Okay. With the Union Bank of India, should I write it IRC Village BBSR branch?
No, that your lordship may not.
No, yes. Union Bank of India, covering an amount of rupees 11,58,414 and 14,54,146 as on 31st March 2024 are still lying. Now, are sufficient enough to cater the quantified demand under the said notice. The senior counsel, on instruction from the advocate and record of the petitioner, submits as though the maturity amount of the aforesaid fixed deposit is shown as 31st March 2024, but under the instruction of auto renewal, under the instruction of auto renewal, comma, the same has been renewed and is still lying with the bank.
Correct.
Is going by the submissions advanced before us and believing the same to be a correct and true instructions received by the counsel for the petitioner, comma, we therefore direct the department to issue instruction to the respective banks where the account held by the petitioner has been attached, comma, to lift the such attachments, except to the extent that the aforesaid fixed deposits mentioned herein above shall remain attached and shall not be permitted to be withdrawn until the order, until the specific order pass by the appellate authority in the pending appeal. So, with these directions, the writ petition is disposed of. No order is to.
As an alternative, just let's may kindly bear with me. The statement which I have given, bank account details, as on 29/4/2025, two account numbers are there. Corresponding balance is also there. 18 lakhs 54 and the other one is also.
No, that is up to 24.
Up to no 29/4/25. 29/4/25. Yesterday only
We have simply said these two fixed deposits. We have not really impinged upon your bank accounts. We have not said so. Only this thing is that these are the ideal amounts which is kept under the auto renewal.
correct.
It would remain attached. Don't worry. The rest open. Whatever you want to do.
For my satisfaction, I want a reaffirmation from the client.
That is what I recorded. I knew it.
Just a reaffirmation for the purpose of.
But she has said so.
Therefore, may I suggest as an alternative logic, in these two accounts, PNB accounts,
Money is there.
18 lakhs and 6 lakhs respectively are there, which will also put together be more than 23 lakhs. Your
We
lordship.
are not attached. These two are not attached.
Attached, your lordship. We can put these accounts to be under attachment.
No, we will pay the money. You can say.
Madam, again you are saying without instructions.
Yes.
Your instruction was in relation to an FD because this chart is prepared by your client.
Yes, your lordship.
Right? So let it remain because we treat it as an instruction. And FD is an idle money. These are the readily available money where you can do a work.
Correct. Absolutely, we are not.
So it's better. You need a working capital. And these are the working
These are
capital
interest
available to you.
Interest bearing.
Because your lordship yesterday suggested that the interest should not be affected, so that would.
So
What? What interest?
FD, because it's an interest bearing.
No, we have simply attached those FD. These FDs should not be attached. We have simply attached those FDs.
And the rest of the FTs have been lien marked, that may kindly be.
We have already said, apart from these two FDs, whatever, they will issue immediately a order to release it.
And
We have already said.
yes. And
Yeah.
annexure 11.
No, the appellate authority will.
And we have said that so far as these two amounts, FDs are concerned, which are attached, it is subject to the order that may be passed by the appellate authority. If the appellate authority allowed to appeal, then their attachment will also go because the order is. So ordinarily, the appellate authority will say that there should not be any further attachment of those evidence. That I have already said.
So we have to one more pair. There's prayer to quash Annexure 11 as well, because
What?
that was the demand notice that was initially raised. Subsequently,
Madam, when it is quantified, we say that this is all, and we have already instructed the department to issue a letter to all the banks where they have already issued a letter for attachment, so that they will deattach those accounts, except to the extent of these two entities. There's nothing more than that. This is what we say.
Now during the pendency of appeal, since we have directed to lift the attachment, you can move another petition for under 220.
yes, okay.
Where is the hard?
Only it's liberty to reaffirm if required, otherwise no matters.
What do you affirm?
I will personally verify by just to reaffirm. Just there, I understand.
That you can do.
Fine.
Press admission item number 2.
But this is a public interest litigation, my lord. This is a public interest litigation, my lord. Here, my
You
lord,
are a public spirited person.
my lord. Here, my lord, the opposite party number 4 is the superintendent of
You
excise.
are a very powerful person.
Is the candidate.
That is paragraph 3 is reflected there, sir. It is still public interest litigation.
(192) license, wine shop license has been issued by violating the rule 26 of Odisha excise.
What is happening? Madam, what is this going on?
Not should I seek instructions from the
This matter appeared in the month of December. Now we are in the month of
December. It was in another bench, your lordship. It was assigned to the PI bench in December, your lordship.
I humbly pray, your lordship.
Madam, it is 2024. Kindly appreciate the
Yes.
complaint is made in July 2024. Now we are in May, around 10 months.
assignment of a matter to another bench requires a fresh instruction.
Lordship, we were, since notice had not gone, we were not asked for any instructions. Today itself it has come. I will seek instructions, your
Madam,
lordship.
instruction must have been received on the day when you received a copy of the writ petition.
Your lordship is
Not
generally.
that when the
notice
matter
issued
appeared on
with
13th of
instructions.
December, you had a copy of the PIL or a public interest litigation writ
Yes,
petition
your
with you.
lordship. A letter was sent by my friend here, my colleague here, your lordship. The SP of Ganjam
If
has
that is
written
not
to us.
complied, that tantamounts to contempt as per division bench judgment of this court in
No.
2000,
If
2000 volume 1 OLR.
Lordship, the practice is the day it comes
So
up for
practice
hearing.
is 2000, in 2000, a division bench of this court has directed the chief secretary to take action against the hearing officers. It tantamounts to contempt. I have also referred to in one of the,
Not been indicated to Lordship, how will they know that they are supposed to give instructions?
you have not sent any,
No, your Lordship, only on the last.
you have LMS,
When the matter did.
you have LMS,
Yes, your Lordship.
then that goes without saying. Then why is LMS? What is the purpose of LMS? What is the purpose of LMS? Why advance copies are given to you? Advance copies are given to you for that purpose only.
Your lordship
take-
is also a part of the bar, your lordship, you know the practice, your lordship.
Yes, I, as additional standing counsel, I was doing that for the department. Ask anybody.
We are a failure, your lordship.
I don't know.
We are a failure, we don't get the instructions.
I
We
don't-
are a failure on the first day, we don't have instructions.
Perhaps,
We are a failure.
perhaps
your
so.
lordship. That may be reflected, your
Yes.
lordship. Yes, it may be reflected.
Sort of argument.
Lordship, when I'm saying that when the notice goes, I'll get the instructions, your
The
lordship.
court to a very difficult terrain. My own judgments are in this line. I kept mum for one reason, because there I have already been very critical in this regard. There the system is that no writ petition could be listed unless the copy of the writ petition is served upon the authorities 48 hours before the date of posting. The purpose of putting that particular cap of 48 hours is to ensure the counsel who is representing those authorities to take an instruction. And if the instructions are not taken on a date of listing, I have held already that that tantamounts to accumulation of the pendency of the matters. This is one of the ground which explodes the dockets of the court.
Your lordship has
And
been here
the
for a
courts
month.
are not in a position to proceed and dispose of the matter on the very first day, because the counsel who is representing the department is unable to secure the proper instructions.
Your lordship has been.
That's why I
Your
really,
lordship
I
has
kept
been-
mum, that's why I do not know what is this. But what I noticed was that the difficulty is this matter was listed on 13th of December 2024. So the council, either you or your counterpart, whoever be before the sinking bench, appeared. It's not that they did not appear. I think Mr.
SK Swine.
SK Swine was there. I think is a
Your
part of.
lordship, this is my friend here on the last occasion, your
No, I'm
lordship.
just saying,
He had
he
been-
appeared.
Yes.
And he appeared, and there was a direction which is passed. The court has taken a very, very strong view on that. And then say that that amounts to a public interest litigation.
Yes, your lordship.
So it has relegated the matter to this bench as a public interest litigation. But the instruction should have been secured in the meantime, because the instruction would be one and the same. They are raising, only flagging an issue that in this particular district, there is, the competent authority, I do not know, SP Excise of the Chhatrapur, Ganjam. Their allegation is that he has issued multiple licenses without following anything, without looking into the complaints, nothing of that kind, and all these licenses have been done in violation. Your instruction would have been, first, whether there has been any issuance of the licenses. As he alleged, how many licenses have been issued in that particular area? And whether all the norms of the law has been duly followed. That's the only instruction
Yes,
we
your
wanted.
lordship, what had happened is on 12/3/25, this matter did not reach. Yet my learned friend here had asked for instructions. We have received an instruction from the SP Ganjam.
Yes.
He has said that I have maintained the law and order situation. I have been seeing that nothing of this has come to us, your lordship. But I have
not a law
not
order
received any
situation.
instructions from the district
So
magistrate.
he's
or the-
misdirected. He is then misdirected. Question is not a law and order.
Yes, your lordship.
question
So I
is-
want to seek fresh instructions, your
The
lordship.
question
on
is
this issue itself.
that
is
issuance of the licenses in contravention to the provisions. That's your grammar.
Yes, your lordship.
Section 2.
So why law and order? Law and order is a state subject which is different. There is no reporting commotion there in the area. There is a dissatisfaction expressed by
Yes,
the
Your
villagers or the local inhabitants. That's a dissatisfaction. But there has not been any commotion. Why the SP will come? Only thing is the licenses are within the parameters of law or beyond the parameters.
That is what the SP has also intimated, that has to be the district magistrate and the superintendent of excise who has to give you instructions.
Would have reported.
We have also written to them. We are yet to receive instructions, your lordship. So I was seeking that another date I would get the positive instructions. Your lordship has been here for a month, and your lordship knows that whenever there has been, your lordship has insisted, we have come up with instructions. 1 or 2 cases we have failed, your lordship. We have always tried.
There are exceptions, I appreciate it.
Yes, Your Lordship.
I appreciate, but in most of them, there should be. That is what I was thinking.
First date, Your Lordship, since the
So this is
voluntary
the matter which
petition
was
is-
listed, madam.
we-
That difficulty is, had it been a fresh matter for the first time it is coming, we have not uttered a single word the moment you ask for saying the instruction. Have we? We know that those impediments, those predicaments which you face as an additional government advocate, we appreciate. There is no difficulty. But when the matter was already there, has been taken up once, and then
We
4,
have
5
sought,
months
Your
have
Lordship, on the
passed.
last
It
occasion.
is
my
not
friend
expected.
has
That is what we
Yes,
we,
Your
we
Lordship.
wanted to record dissatisfaction, nothing more than that. And if you invite, I can dictate a judgment. There's no difficulty on that. There is no difficulty.
It's Your Lordship's court, Your Lordship.
Yes. Flagging us is the serious allegations pertaining to the issuance of what is this? IMF. What is this? IMFL.
IMF, on-shop and on-shop and desi liquor shop.
IMFL. Both on-shop and off-shop
Off-shop,
licenses
DC liquor
issued
shop.
by the excise department in
Superintendent,
Chhatrapur area within the district of Ganjam without following any
Rule 26 of
without following any statutory provisions. And therefore, such illegal functioning of the shops should immediately be stopped. The matter was listed before the single bench, who was of the opinion that this matter should be treated as a public interest litigation, as the petitioner does not have, as a petitioner being a public spirited person, have raised the issues which is of a larger public interest. Ms. Patnaik, the learned advocate, additional government advocate, submits that she has been engaged in the matter by the department, and therefore she needs time to take appropriate instruction from that committee. She submits that the SP has communicated that there is no law and order problem prevailing in the said area. But we find that the allegation running into several pages does not contain any such allegations of a public commotion or a public unrest at the local. The grievance hovers around the distribution and or giving of a license indiscriminately without following any procedure of law. On being asked, Ms. Patnaik submits that the instruction is needed from the concerned department.
From the district magistrate and the
That is the district magistrate
the superintendent of excise.
and the superintendent of excise. Stop. We therefore direct Ms. Patnaik to take instruction from the aforementioned appropriate authorities and disclose the same when the matter would be listed next. How much time you want?
On 5th of Monday.
5th or 6th, whatever.
6th.
Yeah.
6th. Item number 3.
Recently, the former petty officer
Your former
petty officer.
petty officer. Why you use this term petty officer? Is a resignation.
While he was working at he was
This is in defense.
Not Navy, naval.
Yes.
But naval, Indian
Naval,
Navy.
naval designation is there.
Yes, sir.
Defense, naval is a part of the defense system.
Pilot.
Oh, nice.
Well, I specify that he belongs to Indian Navy.
Yes, naval.
while he was working as coach.
Why these colonial expressions are still contained? Do not know. It's out of context. But why you use the word petty? Petty word, the denigrating word. You cannot be a very good spirit. Anyhow, we do not want to just ponder upon it. Some appropriate word can be why. Yes.
While he was working as a coach in INS Chilica, he was disabled 30%.
He has a 30% disability.
Thereafter, it was
His disability means a locomotive, visual, or what?
due to long time work there. So I'm placing that running with three, paragraph 3 minor.
What is, can you specify the
Specify
disability?
that.
There are multiple disabilities. I just wanted to.
I'm placing
Is a
paragraph
locomotive disability or it's a mental disability or what?
local.
Locomotive, what?
But while I'm placing paragraph 3 of my petition number, it is pertinent to submit that INS Dronacharya Kochi Navy organized a 20-kilometer cross-country run in 1993, during which the appellant serving as a coach participated and sustained injuries after falling on his left hip joint.
Okay, that's a locomotive.
Despite his condition, he was subsequently posted to an operational shift aboard R-class frontline warships, where the injuries worsened. The aggravation of his condition was further compounded by departmental negligence, including inadequate medical
What do you want
treatment.
then?
My lord,
What-
thereafter, I have prayed for my rehabilitate in promotion in another post. As per there is a guideline also. According to my immediate officer, has also communicated 3 letters there. Running page 43, 44, and 45. Specifically, I am placing that running page 45, my lord. The settlement of that is the Lieutenant Commander. Written to
Where is
the
the guideline?
my lord guideline is there.
Where is the guideline?
Guideline is the running page 50, my lord. Rehabilitation of disabled defense experienced personnel, my lord.
50.
Para
Yes.
50, running page 50, my lord.
Page 50.
Page 50.
50.
Thank you.
50. Give 50.
This one, this one.
Or this 50.
Yes,
My
sir.
lord, running to 50.
Yes. Rehabilitation of a disabled defense personnel and a member of the families.
Paragraph 1. The existing policy on the above subject is laid down in MSA Department of Personnel and Air OM number so and so. The then features of the policy are as follows. For the purpose of appointment to Group C and equal Group D, post under the central government filed by the direct recruitment ex-servicemen reserved whether during war or in peacetime, but their disability being attributable to military service shall be accorded priority 1 within the retained employees of the government who was already included in that trial. My lord, I have retired on 2008, February 2008, when I was only 45 years old, only 45 years age. So there is a scope
So you were at the age of 45, you suffered an injury.
Minor.
Now, how do you take advantage of this? Now, that was 2005. Now the 20 years have gone. Now you have become 65.
Minor.
What more?
I have immediately I have prepared the matter. Thereafter, I have filed a REIT application in 2013.
You have already attained superannuation.
Well, I am only financial.
What financial?
So I have applied. I have filed a petition in 2013 manner. 2013 I have applied filed a petition. Thereafter, a direction was there, but that was disposed in 2021. After 8 years.
What more? Yes, what's your response, sir?
That is, as your lordship has said, in the meantime, it's supernatural. And the fact of the case that he has not been born out from the service for the disability. In fact, my lord, he has come to join the service.
Serve till the age of.
Yes, my lord.
He is permitted. He was permitted.
2008 is the occurrence. He has been as allies.
Correct.
And he's continued till 2008. 2008, my lord.
So continued this work.
Yes, sir.
After disability, when the injury he suffered, then he was thrown out.
That is not the case.
Yeah.
He joined in the service in 1985.
Correct.
The disability occurs in 1995.
95. Okay.
96.
Okay. 96.
And he
then he was
continued.
permitted to continue till 2008.
2018, and one promotion also given as he stated.
One promotion was given.
Yes, yes.
What should have been given, he claims.
Yes, madam. Subsequently, madam.
No. The promotion was given, or he's claiming that the promotion should have been given.
During that period, promotion has been given.
That is what I really want.
But this case is that when that has been rejected for the rehabilitation scheme, again he is pray for the promotional benefit to the RSFP. But during that course, we have made the specific stand in the counter affidavit. For the promotion of your lordship know that RSFP, he has followed for the next promotion, he has to attend the qualify for that.
Qualify.
That has not been done. That is the reason we have subsequently reject so far as the financial benefit is concerned. And it is an admitted case that he is allowed to continue after service of.
Correct. After he attained superannuation, he has.
Yes, yes. And
now, thereafter, he raised this issue.
Yes.
First is the rehabilitation under the disabilities, this guideline of the issues which is there, that failed. Then he reverted back to claim the promotion he also had faced. That is what your case is.
Since 2005, I am continuing my application. And in thereafter, several correspondence in the department.
What is the order of the single bench?
at page 135. 135. 135.
That was non-effect 137, paragraph number 9, the operating part. There would be only difference attributable and aggravated. Defining that, the matter was closed.
What more can be done now? So that requires, if any promotional post is to be given, then that requires your proficiency, your ability, your efficiency, your merit is to be considered. Otherwise, and that requires some kind of an examination to be undergone. That is what your case is.
And that one time he is also given opportunity to sit in the examination and he failed.
He was given
Yes, ma'am.
for the next promotion, but he failed.
For the rehabilitation, let's know that for the 5% rehabilitation scheme, when the applicant is more than the 5%, there is a for exemption will have. In our counter affidavit, we have specifically that one opportunity will be given.
Counter affidavit page?
Of the written.
Counter affidavit that has been annexed. Running page 78, the maximum time.
Then writ appeal.
Yes, ma'am. Para 30. that in reply to para 6 and 7 of the writ application, it is humbly stated that the petitioner was given an opportunity to appear in the qualifying exemption for the job, but he failed in the exemption. Thereby, the pension could not be provide the job as per the required policy of the VA. And so far the disability pension also be given to the petitioner, apart from the regular pension.
What was the prayer in the writ petition?
Somebody submits.
For rehabilitation. Now, how can you convert into now the promotion at the appellate stage?
Rehabilitation scheme is there.
So
So I have
promotion is not the issue before the single
no
bench.
matter.
So why you are asking that
Rehabilitation.
you should be given a promotion?
Rehabilitation. So according to scheme that.
But you argue that you should be given a promotion.
No matter. That will be rehabilitated. That should be rehabilitated in higher court. Rounding Bill 33, my lord, Rounding Bill 33 was the impugned order before the civil bench. Before the honorable civil bench. Rounding Bill 33.
So you have laid out a new case before us.
No,
You say that rehabilitation, it is rejected. Now I wanted that I should be given a promotion so that I can have the notional or actually the monetary benefit that you argued. And this is not a case made out by you.
Rounding Bill 33 was the order. My lord, Rounding Bill 33 was the impugned order. I had challenged the honorable civil bench, my lord. That was rejected.
The writ appeal arises from the order dated 2nd January 2025, passed by the single bench in WPC number 31099 of 2021, whereby and whereunder the writ petition claiming the appointment by way of rehabilitation upon giving a priority in terms of the guidelines dated 15/5/2019 issued by the Ministry of Defence within the NDV is rejected. Admittedly, the appellant was posted as a petty officer in the Navy, and upon rendering a considerable period of service, that is 23 years and 13 days, he retired after attaining superannuation. It is undeniable. It is undisputed that the prisoner suffered the disability in course of his service career, which is also accepted by the respondent authorities. It is also undeniable that the prisoner was allowed to continue continue rendering services till he attained the superannuation, despite the fact that he suffered disability, and the competent authority has also certified in this regard. After the either at the flagging of the service or immediately upon obtaining the superannuation, the petitioner raised an issue that since the disability suffered by the petitioner was in relation to a discharge of duties in military services, he is entitled to get the benefit of the guidelines dated 15/5/2019. That is the rehabilitation appointment as per priority 1 quota. Stop. The earlier writ petition filed by the petitioner was disposed of directing the authorities to take an appropriate decision on the basis of such representation, which contains such grievances. Stop. The authority, after taking into account all the factors either disclosed in the representation or evident from the record, made a distinction between the disability aggravated by military services and the disability attributable to the military services, and proceeded to reject the conditions that the petitioner does not meet the eligibility criteria enshrined in the said guidelines. Still, after attaining the superannuation, the appellant is pursuing such remedy. Now, pursuing the claim as made, though has already attained the normal age of superannuation in any government service. The guidelines is applicable in relation to the opportunity to be appointed in a central government service after debiting the military services, and since the defense services being an integral part of the entire system concerning the safety and the security of its citizenry and the country as a whole, such onerous duty is always regarded, and for such regarded as regarded to be taken on a priority basis, and for such reason these guidelines were issued that the priority would be given to the defense personnel or for rehabilitation appointment in the government. Since the authorities did not find that the disability can be attributed to military services, the petitioner does not meet the criteria enshrined therein. So, once the guidelines has a benevolent object to benefit the persons who rendered their services in the defense, such benevolent piece of the scheme has to be understood and interpreted and interpret, keeping intact the object and the purpose underlying the formulation thereof. If the authorities have found that it is not attributable to the military service,
it is not open to the writ court to enter into the nuances of the same unless there is a manifest error or a patent error in arriving at the decision. However, a little digression is made by the appellant in the instant writ petition, in the instant writ appeal, where the claim is made on a promotion which should have been given to the petitioner while in service. The counsel for the respondent fairly submits that even after the appellant sustained injury causing disability, he was promoted once, but subsequently, when he claims the benefit under the rehabilitation appointment, where the parameters of judging is clearly provided by way of examination and the other proficiency and the efficiency being judged, the petitioner was found unsuitable and therefore cannot claim any benefit therein. It is further submitted that the second promotion as claimed by the petitioner requires the further scrutiny and the examination to which every person has to undergo. And since the petitioner has already demitted an office after attaining superannuation, there is no question of any retrospective promotion to be given, even for the monetary benefits. So there is no coherent to the proposition that once the parameters for the promotional post is provided, having a statutory flavor, no promotion can be given unless such parameters are fulfilled. Apart from the same, right to be given a promotion is not an indefensible right. Once the said promotional post is required to be filled up on the basis of a merit to be judged by the competent authority. Right to offer the candidature for the promotional post is an inchoate right, but the right to a promotional post cannot be claimed as a vested right, and therefore the contention of the appellant in this regard is unacceptable. We thus do not find any infirmity and the illegality in the ultimate decision taken by the writ court in dismissing the writ petition. The instant appeal sans merit. What's up next? The appeal is thus dismissed at the initial stage. No cause.
Item number 4.
Appearance memo.
What is this?
Not the item 4 and 5. Your Lordship, remember yesterday item 5, your Lordship had directed that 8 writ appeals may come together
Yes,
on
that was the
6.
order of these.
My Lord, this is one of those 8 writ appeals, 4 and 5.
When we directed that matter to the
6th of May.
let it also be listed
Ma'am.
as 6.
Yes, ma'am.
Body of the writ appeal may be summed
Yes,
up.
the order is already there.
Yes, ma'am.
My lord, I am the capator, my lord. The copy may
Yes, I will comply.
So the next.
Item number 6. 6.
In this case, if you also should see the order that was passed in the petition. Till outside running page 25 of the brief.
Yes. Yes, you wanted to hear it out. Tell us when you tell us.
I have no objection to that.
No, there is no interim order to be filed.
No, I understand that.
Tell us.
No, only I want that because he is going to retire otherwise on 31st of May. So if it can be before, maybe next
what
week.
you wanted. It's a very interesting question that has come up. Now tell us at the back end of the service, what should be done? When you did not impose or inflicted that particular penalty which was imposed, she accepted. In the meantime, received 2 promotions.
And then
Now, difficulty is that can there be some criteria which should be followed? Well, tell us.
Any date, 1 week after. Any date, 1 week.
fine, and if it can be on 8th.
After 8th?
8th.
After 8th, let's find out.
No, but on 8th, if it can be taken up.
Is a difficulty on a
No.
any other day after 8th?
No, I was saying on 8th if possible, subject to my learned friends coming.
Match.
Can it retain its position so that can be heard in the.
We'll try, because
Otherwise, my lord, if it comes in hearing, it may not reach.
no,
Can
don't
be
worry.
impression.
Now we have really accelerated our pace. Don't.
I'm so sorry.
Yes.
I may be excused for that.
Item number 7.
Another notice is to be given to anybody.
May I please, Your Honor?
Mr. Nanda.
Yes.
Any notice to any other respondents, or they are the answering?
They are the only.
They are the answering respondents.
They are the answering.
Yes, ma'am.
Item 7.
In this writ appeal, the petitioner, who is an advocate and petitioner.
Where is the order?
Page 23, running page 23.
Running page.
23.
Yes, this is the 28th of March.
28th of March by 4 o'clock, the petitioner was debarred to take part in the election to be held on 29th. Even 24 hours not given. 16 hours before the election, her candidature was cancelled.
It has not decided anything.
Yes, in the, and the prayer person, may I take your honor to that page 59? Prayer,
Madam,
what was the prayer?
Madam, we are in the writ appeal,
Yes,
and the writ appeal is against an order dated 28/3.
yes.
Please read the order, what it says.
Yes.
There is nothing which has been decided by the single.
The
So this is
substantial
all
right of the party, opposite party number 4. Substantial right of the party, opposite party number 4 has been affected, and she has been prejudiced
nothing.
because she could not take part in the election. She could not, her fundamental right to take.
Everything is over. Please kindly consider, because this was of 28/3/2025. Now, nothing has been decided by the single bench.
In the when the election process is started, after that the single bench is how
The
we
matter was directed to be fixed on 16th of April. What happened on 16th?
nothing, the case is not listed, and they are now it is a unholy combination. They are now thinking of to withdraw the writ application after getting the final order. This is a interim order, is but in pretext of final order.
No, it's not a, there is no, it does not come within the bracket of case decided. You know the concept of case decided. This bracket has to be satisfied to become an aggrieved person, because an aggrieved person can only maintain appeal.
Yes.
So
The
now,
opposite party number 4.
where I find a case decided to make you an aggrieved person. Nothing has been decided affecting your rights, except that you wanted an interim order. There is no reflection either of allowing or rejecting. I can understand impliedly that has been refused.
And I am not the
But now
petitioner.
everything is over.
May I present the case, my lord? I was not the petitioner. I was the opposite party number 4.
Correct.
And the opposite party number 1, 2, 3, that is State Bar Council, and the election officer,
Correct.
the one president of the Kotak Bar Association, on wrong identity, even he is not.
Number 4.
He is, yes, I am opposite party number 4, and I was a candidate. I deposited the money and filled my nomination paper. My nomination paper.
Only thing was that there was an undertaking given by the opposite party number 4 that she will appear in person, but she did not appear in person. But
Yes,
the single bench has not taken any exception to it.
May I take your lordship?
Simply adjourn the matter on 16th. Nothing more than that.
No, my lord. This order on 24th and 26th, my lord, the counter affidavit have been filed by the Bar Council and the election officer.
You are not challenging those orders. You are challenging an order of 28.
Yes,
We have to concentrate on 28.
yes.
We do not find whether there is anything which can be said.
The present appellant was the opposite party number 4, and the case was filed by the Bar Association president. He is not competent to file the case even, because the 44 rule says that
we understand those
and
points
it
are
was
available.
maintainable, and this order has been
These
passed
points,
by affecting
Madam,
the rights
please
of.
try to understand the law. These points are available to you. If you raise those points, I am sure that the single bench will decide those. If you want, I can give you a multiple judgments. This is not a case coming under the bracket of this.
May I take your lordship's matter?
Go there.
And that writ petition order, your lordship may see. 25th, 26th, I was present. The appellant personally wanted to do the case, but she was humiliated. I have mentioned in the writ appeal, and she has applied under the RTI that is live streaming may be given. Then that was denied. No, that is not available. And the election officer was present.
Then you should have challenged that order passed on that date,
It was not mentioned on only
then you could have
this is a
come-
biased order. At best, I can say it is a biased order
as an appellate court, I'm sorry, there is no reflection of all these things.
then on 16th the matter could not be listed. And 28th the order
We request the single bench, to list the matter
only
so that he will.
one thing may I mention. 28th in the list the matter was not in the list. Order was passed on in the by 4 o'clock. It was not in the list.
Sorry.
How the person, the appellant will. List I will file.
Just 1 minute, first. My brother is just pointing out something to me. So let us see.
Yes, I have filed, that is annexed 2.
Just find out whether on that day the matter was in
Yes.
Must have been, otherwise the CI system will not accept any order. Has to be, I can do the supplementary list or.
Not in the list.
Let us see.
That is, that supplementary list. That is 25 to 42. Page I give.
Yes. Even if it is there, let us see what can be done. Madam,
It was not in the list.
Madam, there is not a slightest of word which is written or spoken in the order which would affect your right. We will appreciate that if anything which affects your right is reflected from the order, definitely you are correct that you should be given an opportunity, but nothing has been given, and we don't think so that you can raise the point.
What more can be from the order? It is very much visible, my lord, that against me, I am the affected party. I have been restrained.
The right of
it is
appeal.
non-speaking order, so that the order should go.
We'll say.
It is a non-speaking
The
order.
right to appeal emanates from a statute, as a litigant cannot assume such right unless provided in the statute. Even the right to appeal is provided in the statute, yet a person cannot maintain such appeal unless he is regarded as an aggrieved person. Stop. The expression within courts, aggrieved person, has to be understood in juxtaposition with the prejudice having suffered by the litigant, and litigant affecting the right either claimed by or against the said person. A person cannot maintain an appeal unless the order impugned in the instant, order impugned in the judicial proceeding affects the right expressly or impliedly. Yes. The counsel for the appellant vociferously submits that the opposite party number 4 of the writ petition, who is the appellant in the instant appeal, has suffered prejudice not only by the impugned order, but the order passed earlier in the writ petition. It is arduously submitted by the appellant that she was not given an opportunity of hearing and was not permitted to appear to offer her candidate, her or his, what I find her candidature in the ongoing election, and therefore renders her an aggrieved person, or in other words, the affected person who is pursuing her right in pursuit of proper justice. It is arduously submitted before us that the matter was taken without being listed on 28/3/2025 by the single bench, and therefore it is apparent that a principle of natural justice has been violated. Stop. We venture to delve into the records in order to satisfy our conscience on the submissions advanced by the appellant before us. It is undeniable that the order dated 28/3/2025 is a subject matter of challenge in the instant writ appeal, which runs thus. Quote that order number 6 dated 28/3/2020. Yes, sir. The orders passed earlier in the said writ petition has not been assailed independently nor otherwise in the memorandum of appeal filed in the instant appeal. The court should restrict its scrutiny on the order or a judgment challenged in the appeal in order to ascertain whether the appellant has suffered prejudice by the impugned order to make him a personal aggrieved. Though the right of appeal is provided to a party to the proceedings, yet the appellate court would refuse to entertain such appeal if it finds that the impugned order does not affect any right, either expressly or impliedly. The tenet of the impugned order, as reproduced here in above, does not instill confidence, it does not instill any impression upon us that the appellant has suffered any prejudice or any right which she possesses or claim is affected. Paragraph 3 of the impugned order indicates that there was an undertaking given by the appellant to appear in person, on the next day, but she could not appear. Despite the non-appearance of the appellant, the single bench has not passed any order nor made any remark in the said judgment over the said failure or on the failure of the appellant to appear in person, but simply directed the matter to be listed on the next date. We thus do not find that such decision taken by the single bench created any impact on the right of the appellant, nor caused any prejudice, thereby foreclosing the doors for all time to come. Next one. The interesting plea is taken that the said matter was taken abruptly out of turn without being listed on the said date. Do not find any substance therein. Upon noticing the order dated 25/3/2025, upon noticing the order number 5 dated 25/3/2025, the matter was also taken on the board and listed on 28/3/2025 to be taken up at 1:15 p.m. in chamber. Obviously, bearing in mind the sensitivity of the issues, the matter was directed to be taken up in chamber, and we cannot ignore the fact that the appellant might have overlooked such direction and could not appear. Had it been a case that for non-appearance, any remark or the order is passed by the single bench, we would have appreciated the contention of the petitioner, but since no remarks, be it adverse or otherwise, nor any order affecting the right of the appellant is passed in the impugned order, we do not find that the appellant can be regarded as an aggrieved person to maintain the instant appeal. The appeal is dismissed. However, the dismissal of the appeal shall not include the appellant to raise all the issues available on fact and law in the said writ petition pending before the single bench. And if the same is taken, we are confident that the single bench will take into account and consider the same on its merit. We request the learned single judge to give some precedence to the said writ petition so that it may reach to its logical end that
Date may be fixed on date.
I have already requested. I have requested, Madam.
One thing.
I have
May I
said
just-
please give some clarity so that it can reach to its logical.
One thing may I point out only, that with regard to that 28th, while giving undertaking, she was not present. No, 25th, 26th case was
She
listed.
was present, she was present on
Present.
that time.
On 27th, she was not present and the
28th
order
she
was passed.
present. The 28th she was not
Because
present.
I have filed, her mother is
But-
suffering from
But madam,
brain injury.
there was nothing which can be said. We have already dictated.
One decision of this 2025 that it is maintainable, Your Honor may only just.
Let us go, madam.
That is state of Kerala versus
Correct.
Pradeep Kumar decided on 29 January 25.
Will consider. Yes,
Aggregate party can
photo state-
always
urgent photo state certified copy if applied for by the affiliate be given within 3 days from the date of the state.
Item number 8.
No. Last petition, my lord needs to direct the government to get instructions regarding the progress of the.
Yes.
That's why then to 16th.
It is, madam, the eviction of a occupant.
I have the instructions in this case. Joint demarcation was taken up, Your Lordship. They had demarcated, Your Lordship. The English translation of the joint inquiry report is there, Your Lordship. At para 4, there are 3 people whose private lands have been are coming on the way of the road, Your Lordship. So they have given these details to the government for acquiring this much of area from those private individuals, Your Lordship, for the construction of the road. There has been otherwise no encroachments, Your Lordship, nor any other shops or any other eviction needs to be done, Your Lordship.
Yes.
My lord. One thing I am.
So order has, demarcation has already been.
My lord,
done.
I am out of this.
Now,
I am 100% out.
technically speaking, actually, you
Madam,
have no.
With due obligation, I am saying, my lord.
How the
I know that
PIL
this
lies.
will come. I
Now,
know that
then
this.
I'm going into the root.
am-
How the PIL lies.
My lord. Very interesting thing is given by my learned friend public government.
But the pure question of law,
My
how a PIL lies.
My lord. My case is, my lord.
PIL for eviction.
Eviction. Your lordship is kind of going to
The earlier judgment of Chief Justice.
paragraph 4.1 of my.
This is the division in judgment of our High Court. That is binding on me. Please tell us the PIL.
My lord.
Please read. Don't keep it side. Well, bench wanted a requested you.
No, it's a direction. I will not do it.
Please do not ignore the request
Madam.
of the bench. Please.
Yes.
Please, by this time, just go through it because that is a coordinate based decision
My lord.
that binds us.
My lord.
Just consider we are coming within 2 minutes.
We are governed by the rule of law. We are governed by the rule of law, my lord. 100%.
We are going.
My lord.
He is not going very technical on that.
No. It's a great pleasure for me, but my lord, I have gone through the judgment and you always make reference to those judgments. The people who have denied their rights under the constitutional mandate, the right to freedom of movement, right to freedom of movement,
Movement.
my lord, and right to free access. And at the same time, the duty inculcated upon the public authorities as they are the custodian of the material resources of the community. The state is the landlord.
State is a
Landlord. And the material resources of the community, they are the custodians. And duty of the public servant is that to see that the public lands are to be maintained, to be supervised and controlled in the proper process.
that the mandamus for that.
I am coming.
is
I
certiorari.
am coming. How the public authorities are making and tactically avoiding the issue in question at the behest of some interested vested persons.
That's absolutely correct. Probably the issue.
Well,
is
I'm
not-
coming. I'm coming and just I'll show from their report. You know, just
Probably you could not get what has been held by the single decision maker. Question is not that you are.
whether we have finalized matter,
Yes.
whether finalized we have made the case or not.
The question is not that you are remediless. As
My
I
lord,
said,
my lord,
everybody,
whether
whose
it-
constitutional right is infringed,
My lord,
has a right to vindicate his grievance or ventilate his grievance to the court of or to a constitutional court. No doubt.
my lord.
Only thing is the PIL is a unique feature.
Whether this PL is a pro bono PL is a vested
There is
PL.
not- Again, you are I think you have digressed. I am not on that. Pro bono or with vested interest or something is not I am concerned about. What is there that if there is an infringement of a constitutional right of every citizen of the country,
Right.
he can approach the constitutional court, no doubt,
For enforcement of those
for
charges.
enforcement of that constitutional right.
Right.
For that, Article 226, the writ is there. There's one. PIL is a very unique concept. Does not really is reflected in the Constitution. It is not. It is a device innovated by the judiciary, the constitutional courts,
Article
Supreme Court,
inherent power.
and all
130.
that a person can raise those grievance, reminding the state of their constitutional obligations
Oh, yes, sir.
in the larger public interest, in the larger public interest, as distinct from a personal constitutional.
Bended.
This is what we wanted.
Even if a
When
single
you talk
person,
about- When you talk about any specific eviction drive to be undertaken in a particular area, this can be ventilated by filing a writ petition, reminding them of their constitutional obligation. But public interest means it should be like that, that where you have flagged an issue, that throughout the state, the government is showing their dormant and lethargic attitude in not taking an action as mandated in the Constitution. So it will be an omnibus thing where the court can definitely intervene or step in and then reminded them of their obligations. And then in an omnibus manner, the court can pass an order wherever, whenever it is found by the court that this thing has happened. Then the court can direct to do it. Not specific, but in general. You have really made out a case of a specific nature. Saying that this is the land where the eviction has not been secured by them. They are occupying the government land. Means they are the encroachers who have no right over a specific property. That is what I'm saying. As you say, in a very generalized manner,
my lord,
you would have raised that flag in issue
My lord.
as a PIL.
my lord, come to
We are
paragraph
not going
4.1.
too technical, I tell you, because I have noticed
My lord,
in slew of litigation which is really coming here.
Madam, come to paragraph
If
4.1.
we go very strict sense, then
Madam,
it is problem.
Kindly come to paragraph 4.1 of the writ petition.
Please,
Page 34.
4.1.
4.1.
Yes.
That there is a road connecting from NH 16 at village Pahal to Niyali Madhava, upon which the villages of Johora, Pahala, Maidrapada, Panchavati, Anantapur, Jarisasan, Usma, Nagiri, and so all those matters.
True. These are, I am again saying, sir, when you specify the things that creates a problem.
My lord. So our grievance is that these are the areas and the road from NH 16 to Niyali Madhava around 4 kilometers. Concerning those, and my lord, come to my lord, page 52.
Now, why you are not?
Let
Why
me
you are not
counter.
taking an eviction drive if somebody is unlawfully encroaching upon the land? And now it appears that you have taken some steps to identify.
No, my lord. My lord, what happened?
Now,
Let me submit.
Why you are not taking
Your Lordship, para 2 of our instructions, it says that in the revenue map, the road in question exists on the following plot.
Correct.
That is 599 plot under Khata 465.
Correct.
The next paragraph, Your Lordship.
What is the general public? That means it is a garment.
Page 52.
Then
Page 52,
that
my lord.
as for field demarcation, a stream is flowing on the above road alignment, which was not there in the revenue map. And 4 says that the road in question now physically exists on the following 3 plots.
Which belongs to some private individual.
Yes, Your Lordship. So they have to acquire those lands for the construction of the road. So they have intimated the government and they will now notify and
Whether the petitioner is any one of them.
No, Your Lordship.
My lord, the person who encroach the land, he has signed, Your Lordship, kindly see.
No.
The person,
What she has.
it has not within the knowledge of the villagers.
Let us find out the
My
issues.
lord.
Let us. What she says that in certain areas
My lord.
there.
They are not in question. That are not required to be adjudicated. We are not on their private plots. Your Lordship, kindly are going to page 52 or writ petition. The plots we have given the ROR. Page 52. My lord may not got, it is because in Orissa, Your Lordship may have got. And we have asked for 10 to 15 villages. We have only one plot we have visited. And those persons, he is a witness, my lord, Prana Krishna Bhora, my lord, at serial number 4 page. Who was the witness? The son of Prana Krishna Bhora, my lord.
placed to another place. What is the right of the villagers apropos the said policy decision to be taken by the government? That second question that really struck my mind, what is the role of the writ court to interfere in a policy decision? To what extent the court can go? This is what because there is a Panchayat Raj system which is recognized in the Constitution. Constitution recognized the Panchayat Raj system.
It is come under the BMC.
The
Sarpanch, not in
the
the
Sarpanch who is, or the members of the Panchayat who are the elected bodies representing the peoples, if they have taken a decision or something, how far each and every individual of the village has the right to interfere with the public policy. I think please consider the law in this regard. Can you benefit us with any decision of the Supreme Court
My lord,
or of this
keep it,
court?
my lord, Monday, my lord, I'll come over with a
That
written
is what I was requesting.
My-
How far?
No, my lord, it's a direction. My lord, no, don't.
No, that is what we are
My lord, rightly pointed out,
See,
I'll come
because
solve this.
you are raising an issue. Villagers
My-
are
Even if the Supreme Court, my lord, the Honorable Supreme Court said, even if we have private property, even if a private property that has been used for the public purpose, that can be.
Pursuant to the earlier direction, the report is submitted by the additional government advocate indicating the plots which are subsumed into the construction of a road. It is indicated in the said report that the major portion of the land, the road is constructed over the plots recorded in the name of the general public, meaning they are the government land. But it also covers some plots which belong to a private individuals. To make the record straight, it is pertinent to note that the persons whose land is used and utilized for the construction of the road have not come up by filing any petition before this court, but their right is being pursued by the petitioner, being a public spirited person, as the decision would vitally affect the public at large. We invited the attention of the council for the appellant, for the elected petitioner, whether the dispute of such nature is amenable to be challenged in the writ petition, and to what extent. What the query was raised, whether to what extent the writ court can interfere in the policy decision taken by the government or its instrumentality. More particularly, without consulting the villagers of the villagers over the through which the road is constructed. This the matter on Monday.
Well, may take time by that. 15th we understood, sir.
Any days.
15th.
Fifth. Let the matter be listed on
15th. I'll come before with the written, all the papers.
The principle of the Miscellaneous petition within bracket PIL shall not be construed to have created any impediment on the ground to taking an appropriate steps as permissible. Yes.
Item number 9.
May I please? Matter is the public interest litigation matter. Petition is the villagers matter. The litigation matter opposite party number 6 to 25 encroach the government land since long and construction of the building matter. So the villagers are suffering the like anything. The village the nearest to the one Ramchandi temple matter. The devotees celebration the Jhamu Jatra Panas Krante and devotees are facing severe inconvenience. The
Madam, why you not? We are not technically going so strict on that, but at least if they are constructing over a government land, then why will not take any steps?
I think instructions are not given. We will give it a week's time. 6th on
First
6th.
time. Instruction.
On 6th.
7th. Seventh, ma'am.
Fixed what?
7th.
Whatever.
yes, ma'am.
Item 10.
And counter has been filed by the opposite party number 3 and 5, wherein it has been categorically mentioned that the opposite party number 6 is running the claims illegally without taking any.
That is the affidavit, and we have issued notice for eviction.
You have already taken.
No sitting criteria. There is no sitting criteria.
What criteria?
Sitting criteria.
Sitting
Criteria that is given by the local collector, and that is in view of the Honorable Apex Court judgment. I'll produce that judgment. And the other one is the consent to operate by the State Pollution Control Board. Both these license are not available with the person concerned who is running the brick clean. It was only run by only pursuant to the resolution of the Gram Panchayat. There is no consent from the authority. So accordingly, we conducted an inquiry.
You have stopped the operation also? Taken steps to stop the operation?
I have filed an affidavit. If your lordship will.
Are they made a party here? These
Opposite
equipment operators or the kiln operators?
OP number.
Opposite party number 6.
Have you served the notice?
Notice has been done.
Notice is not served earlier.
In the meantime, the eviction notice has been issued. I have filed the affidavit.
Stop the operation.
Yes.
So when you find that these are all illegal. Bound to run the film or this is a big
Clean without
any permission. The notice has not been given. So on the basis thereof, can we?
Not the same.
Where is your? Where? So is a copy of the counter.
He filed on 25/4/2025.
Give us. Give a copy. Where is which portion?
Minor kindly see annex of it's by 5. Eviction notice has already been served.
No. Where is the government which he has made?
Minor paragraph 7.
Then
Paragraph 6, last stanza. At page 3.
the sitting, it's the citing.
Is citing.
I was also confused.
No,
that
it is citing. I'm sorry.
The site.
Citing criteria, certificate.
uh, the petition in the nature of a public interest regulation is at the behest of the minister, bringing himself into a public interest person, raising a grievance of illegal operation of the brick kiln or kiln unit at the site reflect at the right disclosed in the instant writ petition. Taking into account the gravity of the grievance raised in the instant public interest litigations, more particularly the brick kilns are extruding throughout the state without having a valid license or without following the statutory norms. The petition was passed upon to submit a counter affidavit. So the counter affidavit filed by the state revealed that the opposite party number 6 has set up the brick kiln unit at the said site without any valid documents, via the citing criteria certificate from the collector or the DM, the consent to establish and operate the same upon obtaining from the State Pollution Control Board, nor in the royalty, you charge the royalty for this excavation of this.
It's a brick kiln.
Or whatever, the earth is being utilized for
Yes.
that.
Athens sand also. State is losing rights.
Not in the affidavit.
Without paying any license fees or the requisite fees leviable for the same. Interestingly, the aforesaid brick kiln is operating on the basis of the permission granted by the
Gram Panchayat. By virtue of reason.
You are neither a competent authority nor is authorized under the Act to grant such permission and or license. Though the notice is not directed to be served upon the opposite party number 6, as the state appeared on the day when the incident PIL was taken up, but after the revelation of the aforesaid facts in the counter reply, in the counter affidavit filed by the state,
My Lord, we say
we cannot permit
only an affidavit.
any such illegal operation of the brick kiln within the scheme, more particularly at this site where the opposite party number 6 is operating. We therefore restrain the opposite party number 6 from operating the brick kiln until further order that would be passed in instant. The aforesaid interim order is passed, bearing in mind that the appropriate steps has already been taken by the state by serving a notice of eviction. To stop.
Annexure
Let the notice be issued upon the opposite party number 6. Immediately, the requisites shall be filed within 2 days from the list the PIL. Third week, second week.
Reopening.
Other reopening.
Lord, in the eviction notice, only 10 days time has been granted to evict. Now, my lords have passed an interim order and has directed the opposite party
Put the opposite party under notice. So should we give effect to?
No, you give away, whatever. For abundant precaution, we make it clear that the interim order shall not be construed differently by the authorities, creating any impediment in proceeding on the basis of the notice for
Annexure H by 5. Annexure H by 5 to the affidavit.
in accordance with law. Yes, for the next.
Item 11.
Please, Your Lordships. This is a challenge to the assessment order under 148, grade 147. The facts of the case is this. This is a assessment which is there are land losers in the village of Sundargarh. 2006, the set of petitioners are approved before this honorable court because MCL had made an acquisition of the land under the Coal Clearing Act. In 2006, this honorable court directed that the compensation will be calculated and the amount will be disbursed. In 2007, as part of my list of dates, the MCL went in an SLP to the Honorable Supreme Court. The Honorable Apex Court directed for formation of a claim commission. Now that claim commission had to prepare the compensation rule and it has to be submitted before the Honorable Apex Court for the directions and approval. While the commission was working and submitting its direction and approval, in 2014, the operation of the RFC, Right to Fair Compensation and Transparency of Land Acquisition Act 2013 came into effect. The Honorable Apex Court took into account in 2022 that the villages which were not covered under the Coal Bearing Act by virtue of the notification of the Ministry of Coal, they would be covered under the Right to Fair Compensation of 2013 Act. Now, 2013 Act specifies under Section 96 that any agreement or any compensation which is paid for compulsory acquisition of land under any agreement or any award made under this Act shall be exempted from income tax. And the CBDT in its circular had taken that into account, which is at Annexure 1. Your Lordships will kindly say Annexure 1.
What has happened? Now it is exempted.
Now it is exempted. Now the CBDT has come up with a circular in 2016 saying that this RFCL Act of 2013, the LAR Act of 2013 has a wider scope than the Income Tax Act, and it would cover all the lands, be it agriculture, non-agricultural land.
Is that the special act will override the general act?
Yes, they said that it will override. Now, what they have done is, now I filed, now they have, 2019, I received 50% of the compensation was determined to the amount of 70 lakhs. I received 50% of that compensation, which is around 34 lakhs. I also filed my return. They deducted the TDS under 194A.
However, it has to be added to the income person.
I say that 194A and 194LA also. 194LA says that there should not have been any deduction if the compensation is given under Section 96.
Oh, there is a distinction. One, it does not come within the purview of the Income Tax Act or the Act is one thing, and one which is exempted under the Income Tax Act. In a latter case, that be added as an income and then claim for exemption can be made. There is no difficulty, but you'll have to show the amount that you have received. Exemption that it does not, it's not, it's susceptible to be charged with any kind of a. We'll have to show that. But if the TDS is charged, whatever, then you are entitled to a refund if the exemption is.
TDS means that's exactly not a dismissal. The TDS they had deducted, I claimed for a refund. They refunded me back. But now what they have done, they have initiated proceedings saying that this is an escaped income out of the interest which I have received from that compensation.
Oh, that's adding to your income.
And they say that Section 56 8 would apply to it as income from
provident fund. Whatever the interest which is accrued, if it is given at the time of a superannuation, these are all excluded from or exempted from the purview of the income tax. But if you invest that amount, and then it attracts an income stream of an interest, which is
I bowed on your Lordships.
You'll have to pay.
I bowed on your Lordships. What I am submitting before Lordships is this. Now, that 50% of amount which the MCL has deposited in the bank, so the interest which would accrue from that, I have to pay from the income tax that. But Malad, this is an amount which they have disbursed to me directly, 50% of that. Means this amount is the compensation which I'm receiving, and they're calculating the entire amount of interest. So that 34 lakh which I'm receiving,
This is not permissible. That they cannot.
that they have done.
No. How can we do it? Entire amount cannot be said to be an income if it is exempted.
So we are concerned about the interest only.
That's all. That is what I was just thinking. Interest component, yes, sir. You are liable.
That part I'm liable, but the particular aspect which I'm placing.
Where is the decision? They are very categorical. They say the only interest component.
That is 34 lakhs which they say.
No, what more? That is an interest component.
I'll place that.
So, question of computation is one thing that you go and satisfy. We are not going to interfere. That you are giving an explanation that this amount, no, this is a compensation part. We are not going. So computation is with them. You go and satisfy that. We will consider whether it is only an interest component. Show us.
Yes, Lordship, kindly see Annexure 1, which is the CBDT supplement.
Yes.
Page 38. Page 38.
38.
The paragraph 2 in 3 minutes, time and placement. The RFCTLR Act, which came into effect from 1st of January 2014, in section 96, inter alia provides.
Say that it will not come, then exempted from the levy of the income tax.
The compensation is levied from. Then I will place this impugned order, which is at page 85.
Yes.
Page 85, Annexure 15, the impugned order. Lordship, the assessment order starts on paragraph 1.
Yes.
The assessee has filed return of income for the assessment year 2021 on 22/6/2020 with the acknowledgement number so and so, declaring his total income as rupees 2,60,590. In this case, the assessee has received interest on compensation of land of rupees 34,46,837.
And skip the assessment. So the interest component means interest on 34 lakhs.
This is the 50%
This is what
of
the
amount
compensation you receive.
This is the 50% of the amount I have received.
It's not say that entire 34 lakhs, sir. The interest earned on 34 lakhs. That's a very simple language.
Well, since that means the compensation itself, what I beg to submit to the Lordships is this. The compensation aspect is now, because 2013 LR Act is a benevolent legislation.
Appreciated. We are also concerned with section 96. It says that it will not be levied. It says no difficulty. Compensation component will be totally outside the purview of the income. But whatever income which you generate from the compensation.
Because it is
You
not
are making a very interesting point. The amount is saved by an individual assessee after paying the entire tax. And then that amount is invested. And that amount augments an income by way of an interest. Then according to you, this is the amount over which I have already paid tax. There cannot be a double tax on that. I paid, which is my amount. So anything which is charged on that amount will not be coming under the purview. Absurd. Absurd.
I
will be also happy.
I'm on the other point.
I think everybody who is sitting here will be happy if this proposition is accepted.
It's the 50% which is now deposited by the MCL.
So whatever that is a 50% or 100%. The amount which you received by way of a compensation is outside the purview. They cannot be charged any income tax on. That's absolutely immune from the income. But if you invest that amount somewhere, and if it generates some income from
The compensation and a whole
Only
system
that component is.
the
It
compensation.
is then very interesting. It will be under the land acquisition.
This is also going to affect a lot of family
In
because
Land
they-
Acquisition Act, the acquisition proceeding is initiated, the compensation is paid. For all time to come in his life or future, that amount, even if you invest somewhere in a mutual fund, you invest in a share, you invest anywhere, and whatever the amount is earned outside, no, will not come. No income tax.
because well, now what they are disbursing, the MCL is disbursing right now.
Is the interest card. You can't. This is the notice, the first card. Lost. You go, you have already replied to a notice.
I have a reply to no. This is an order.
This is an order.
This is an order, and they also say in the order that I'm
Never we do not invite us to make comment on them.
Lordship may.
What? You have a right of appeal, you go there. You have approached
I have not approached. I'm challenging.
within limitation or beyond
It's
limitation.
beyond limitation.
Within condemnation, if file a condemnation petition, it should be admitted to us.
It will be- In the base of the order also means they say that I have not responded to any notices. But however else I have responded to the notices. Page 101 the same.
He has not really raised the issue in a correct manner. The difficulty I tell you, what he has not really gone into that. What has happened is that he received 35 lakhs as a compensation. Since there was a delay in payment of that compensation, they have awarded an interest on the 35 lakhs, which comes to around 34 lakhs. Now, with that being the position, then it is an award which is passed. Whether the award means both the principal amount of compensation as well as an interest as a composite unit. As a composite unit, please consider. Or it will be segregated. There are two aspects. So we have to say 96 talks about the award or the agreement outside the purview. Whether both the components will constitute one unit of award or it is segregated. Why I say so is this. Reason is because one judgment of the Supreme Court is stuck in my mind, not in the income tax, but in relation to an arbitration matter. It's a Heidel engineering matter, 3-judge bench of Justice Bogde, if his lordship then was. Then the question arose that what could be the meaning assigned to a expression awarded sum under the arbitration. Awarded sum would mean the principal amount along with an interest during the pendency of the proceedings. And then the award is passed and further levy of interest over the awarded sum. The question arose that this awarded sum includes an interest. Yeah. So there cannot be a double interest over the interest. It was interpreted no. Once it is an award, then whatever is infused into it will constitute one unit. Means composite meaning of award. And if anything is to be charged on the award, then that would be separate and it will constitute a homogeneous class. Here the same thing is award of compensation.
With interest.
With interest means it is a form, it is a part of that award. If it forms part of the award, then the word award has to be interpreted.
I'll have a clarification. In the case
of he has not raised that point.
Mahendralal Naranga, which has been affirmed by Supreme Court, it has clearly defined that interest portion will be taxable.
No. That's why I'm again saying that
after
the definition of the word award, award has to be understood in that perspective.
Prior to 2010, that interest portion was also exempted and under section 1037. After introduction of the section 56 to Italian 8 on 1/4/2010, interest has been taxable. And Lordship, 57(4) also says we are giving 50% compensation. We are not charging tax on 50%.
Exemption talks about the section 96 of the FCN in Land Acquisition RNR Act 2013.
Sir,
correct?
Sir, 2010, you are referring to 2010, right?
Right, sir.
Income tax act.
Right.
So Parliament was conscious about that amendment when they have brought out this 96, section 96 of this fair compensation. It is in 2013, right? So
it says that no income tax or stamp duty shall be leviable
on any
award.
Any award, yes.
Please consider. Or agreement made under this act, except under section 46. And no person claiming under any such award or agreement shall be liable to pay any fees for the copy of the same. Right. So if the purview of the provision of income tax or act or the income tax is excluded to operate, then one has to understand that what should be the meaning of an award or an agreement to be given. Let us show by agreement the price of the land is fixed and also the interest is also fixed within the agreement. And then total amount of the consideration is mentioned in the agreement. to be paid to a landlord, then whether this interest component can be segregated for the purpose of applicability of the income.
Similarly, a lordship in Delhi High Court in 2024, he has given in our favor.
You appeared in Punisam.
Punisam.
You appeared.
Lordship.
Can you bring out that judgment of Heidel engineering or something on the Supreme Court? Are you aware of this? There are two judgments. One is a clarificatory judgment, one is a parent judgment, or three judge bench. I think presided over by Justice Gopte as his lordship, then the Chief Justice of India. That from my memory, I think it should be 2013 or 14. Heidel engineering, if I'm not wrong.
Heidel consultants.
Heidel consultants.
By taking our Orissa High Court judgment, that is J.C. Roy versus irrigation.
Heidel consultants. Or Heidel engineering, I don't know. My gut feeling was engineering.
I'll verify that.
You just look at. Heidel consultants, yes. This is for this judgment.
Yes.
Yes, three judges.
Yes.
Authored by Justice Gopte. And look at that. The same point was involved. What would be the meaning of the word award or awarded sum?
And Punisam also on the same line.
Punisam in the law.
Yes, that is under
Which year?
illicit.
Which year?
This one is.
That was the claiming of tedious amount in Punisam.
Yes. And there is a clarificatory judgment. I think there is another clarificatory judgment. Two judgments are there on the same. Take into account. Why you are not raising that issue? You have not responded about it.
I did read section 96.
I raised section 90.
But you have not formulated this. That what should be the meaning of the award appearing in section 96?
It's, what I to submit was that to include everything. It's the interest component and the
consider when
1 week.
these take into account. And there is a clarificatory judgment also because some interpretation was made wrongly. Then the bench clarified it that what I made like this. So there are two reported judgments of Heidel consultants.
proceeding with recovery also.
Structure. Item 22 was the question of the production of the father and daughter in case. Taken
Yeah,
as
the recovery.
from your logical.
Milords, I'm in that I'm appearing that matter. Milords.
Comment to.
What I may humbly submit, Milords, the boy has come, the girl has been staying with the father for the past 3 months.
Why you are arguing, comment to, we will consider you.
What I'm praying before my lords is they may be given 10 minutes time to speak. Milords. The boy has come and the girl is.
Mr. Counsel,
I bowed.
Yes.
Item 22.
Item 22, Milords. Herein is the case wherein, Milords, the petitioner is the husband of the girl who's appearing before my lords. And we have been legally married and the marriage documents have been enclosed with my red petition. Milords.
What is this? Is a Habeas corpus application.
Habeas corpus application.
Habeas corpus, then now the girl is.
Girl and the
rescued.
father are here. I have also called the petitioner here, Milos. Now, Milos were of the opinion that you would ask the girl.
No. It's the wish of the girl, which is now it is major or a minor.
Major, your lord.
Major.
3 years of age.
23.
23 years of age. She's saying that she had left with that boy, and on a blank paper, he took his signature. He was not willing to convert and marry. But after that, they took on a blank piece of paper, they've taken his signature.
Order dated 8 April 2025, where the matter was adjourned at the instance of State Council, and he was directed to obtain instruction as well as the SOP regarding destruction of the unfit liquor.
My lord, may I?
Started-
There must be some SOP to be.
SOP.
My lord, your lordship had put me 2 queries. The order, the impugned order has been passed contrary to the consent order passed by this honorable court. And your lordship had put me a query that whether whether there can be concession on facts. So if it is on concession on fact, then you are bound by the order passed by the court. This is one. Then number 2, regarding the SOP. My difficulty is with respect to the self-same petition, they have provided instruction in respect of another writ petition. So all that I pray, the matter may be taken up on Wednesday.
So why
So that
the SOP is there? Because in the NDPS cases, one last judgment of the Supreme Court which says that there must be some
SOP.
or destruction of those. So if these are the spurious, the liquor,
Sedimented liquor.
then in that event, there should be some kind of an SOP.
SOP, yes.
So that you can dispose of. It should not be circulated again or
No such.
may intoxicate.
Yes.
Something.
That has to be destroyed.
So now the SOP for destruction.
Yes.
Both
How you will destroy,
but they have
I mean,
given instruction in respect of the same petitioner, but in a different case. So only I
What
pray
it
on
is
Monday.
really wanted because it is a larger public interest.
Yes. I'll produce that. If at all it is there.
Because of my age, your lordship adjourned this matter.
Understand.
And my lord, on 8.
So my lord, on 18th, I was placed for the interim order, and the matter was adjourned to 17th. 17th, it was before lordship, but could not reach. So I am facing difficulties. My lord, the unit is closed.
To continue till the next.
There is interim order not yet passed. Your lordship may pass.
Whatever. Oh, not passed.
Not passed. Because lordship we kept it 17th. 17th not reached.
Then 17.
Because the manufacturing.
Come on, 8.
And on 8.
And
But-
ensure that.
I'll ensure.
What is the difficulty? my lord?
Item 13.
Even ensure.
Unit is closed to 1 month,
Over.
50%.
Yeah.
Only I pray, my lord, till 18th I may be protected.
8. Come. 8 he wanted.
The last.
Today is the 30th. So you can wait for 7 days more.
Because I am not a question about manufacturing, it's a question
No, it's not.
about livelihood, my lord.
Anyhow, the intention, the mens rea is to be taken into account. knowing fully well whether it is spurious or not?
No, my lord,
That is another question we do
my
not.
lord, the chemical examination, it has to be decided as per the statute, it has to be destroyed.
Item note 13.
Item 13 is RC cancellation.
Non-filing.
Non-filing returns.
Yes.
Both the cases.
Both cases.
Yes.
Item 14.
In my loss. I can't remember the other day. Because the order of assessment, there is a table annexed to the order bills. The lordship will find a gross total income, which was determined at 4,477. Whereas in the computation sheet, the lordship find there's a glaring error. They made it 9,255, resulted in demand of 20 crores or more. Whereas the other day also I got a lordship notice. I tried to file a rectification application. The screen portal which I have annexed to this petition also will find the drop down that doesn't show for rectification of this computation sheet bills. This is one. Secondly,
We have observed.
yes, your lordship have also observed for the subsequent period, whereas the very same issue where the appeal of the allowed appeal. Your lordship also directed my friend to take instruction. Whether the same can be applicable for this year. The same thing, the exemption already been granted by the operator authority, only by limited prior to lordship bills. If there's all the glaring errors and in view of the distance for the subsequent period, in the case of same assessee allowing exemption, is a matter relegated back to the assessing officer. In terms of that, let it examine and pass the order.
The rectification within a week we'll correcting the rectification is going to be done. And if we produce all the documents to the assessing officer.
Only documentation of figures.
But
also the
First appellate order, passed in the subsequent period.
He demanded that some document which was not filed by them. Let him file that document also and it can be remanded and they can consider accordingly.
Item 15.
Item 15, your lordship, is a RC cancellation order. I've taken the signature of my balance sheet.
Item 16.
Item 16, my lord, I was supposed to take instruction as to the alleged illegal construction of one community center, taking a portion of the schools premises, so also road premises. I was talking to the officer concerned because I didn't receive in writing in reply. So I was talking by tomorrow they will give it. And they also, another thing they said, complaint is before the collector regarding demolition of that construction. Collector is to take a decision very shortly. This is the verbal instruction I have received, and I have been assured that by tomorrow or day after, the instruction will be.
Keep it on Monday.
Item 7. Item 17.
Avoid any contribution.
Item number 17.
The last occasion you will also have directed me to obtain instruction from where from where the department has got the address as reflected in the so called notice on order in original. I have obtained that instruction, but the facts remain that the petitioner has received the proposed notice along with the order for order in original on 28 March 2025. 25.
Similar to yesterday's case.
Yes, ma'am. But in this case, what has happened? The petitioner has not got the opportunity to reply to the so called notice. So, subject to your lordship's acceptance, if your lordship is set asiding the OIO and directing the petitioner to reply, then the petitioner.
But in the meantime, let's since 1 month.
You have received which mode?
Directly, when
Directly
through the authorized representative.
Your lordship kindly come to page 60.
28
March.
I have annexed that. That acknowledgement I have annexed.
Your lordship will find it at page 61.
So that he will produce on says
Let's see, in the meantime, all the accounts have been.
if the order goes, then what remains?
But if that has not been.
It's saying that the order goes, then what remains? So you may be given an opportunity to file all the documents he will consider. So any action taken on the basis of that order, which is now,
Obliged, yes.
so they know. Yes. Yes. Yes.
Item number,
This program, yes.
item 18.
Pardon me, let's see, item. I may be pardon me, let's see, item 34. I have filed the visual memo. It is in bold. Item 34, I have filed the visual memo.
Withdrawn memo, 30?
34.
34.
Oh,
Memo is there.
okay. Please for the other side.
City.
34.
I am also acting on this.
So there is no interim order,
No.
nothing.
No.
First time.
First.
Okay.
No.
Withdraw.
Yes, ma'am. Item number 18.
Your lordship, in it's a GST 7 lakh member in application GST 13. It's not 71st year. No, yeah. You calculate
This is. And this. Is for the.
Item 19.
like on passport. He is on another passport. Mr. Dolai, please one.
On his legs.
Come to other. Email and agree.
Ah.
No, it's urgent.
Acha. Yes.
20.
I can come to 180 meter.
Yes. One eighty. Oh, short.
All some meter.
3 meters.
All faults.
Finish up this matter. Many matters have been tied up.
It may needs to be hard. It has been fixed. Yes.
Definition for the bar. Both bar.
Yes.
Item 21.
Here minor.
20.
Yes. What is this? Wash.
Yes, my 22 days.
6-2. Where is the order of 6-2, sir?
My page 39. 22 days delay, my.
Oh, please.
Yes, madam.
No,
My private party, I am applying for.
that's notice. Notice 50 days. Notice is on the section 5.
Yes.
First time.
What is it? The rotation of.
Well, on the reopening 18 June.
18.
Item 25.
25 manner is appealing for the respondent manner. I'm appealing for the respondent item.
How much they delay?
186 days.
I will file objection to the.
He can file, but in view of the recent amendment carried to the 2020 rules, this matter can be disposed of. Lordship can otherwise also upheld the order passed by the single judge and dispose of in view of the amendment. That his case for rehabilitation assistant appointment can be considered. I'm not submitting against him, but it's rather
He is going in your
Yes,
favor
sir,
and say that
he is going in my favor. Because the amendment rule has come into force from 6/4/2025.
or pending application.
yes. But the 2020 rule, there was a provision under.
The recent one will prevail.
Yes.
Now you say that on the date of the death, the rule which is prevalent shall apply.
Yes. Yes, that is the order passed by the honorable single judge. Now it has come by way of this amendment.
Judgment, I think, Himappa or Himaya
Yes.
of the Supreme Court, where the court has considered all the earlier judgments, even including N.N. Santosh of a three-judge. N.C. Santosh.
N.C. Santosh.
N.C. Santosh. Thereafter, Bhimappa.
They said that will be considered.
Or Bhimaya,
Yes.
whatever. Either Bhimaya or Bhimaya, either Bhimappa, whatever.
Yes, the honorable court, the honorable apex court said that on the date of consideration, whatever will be the rule, that will prevail.
That was taken into account of that.
Yes,
It says in Bhimappa,
like in N.C. Santosh.
there are three line of judgments. On
Yes.
this. One says that on the date of death of the employee while in service,
Yes.
the rule which was prevalent shall be taken
Into consideration.
Second says, line of judgments of the Supreme Court, that on the date of consideration,
Yes,
the rule which is prevalent, that should follow.
yes,
Third line was that on the date of an application,
whichever rule
then
was
whichever rule which is applicable, which is prevalent, that
Yes.
that would count. And these are the three principles that really counts.
Yes,
And this is taken into consideration in Bhima.
yes, ma'am.
And
But in the present case,
harmonization has been done in that case. And it really says something very interesting. If the subsequent rule inure to the benefit, larger benefit, and does not curtail it, then the subsequent rule will apply.
yes,
That if you read that judgment is a very, very
Yes.
interesting and classical judgment of that.
So this is compassion.
yes.
Be compassionate.
Now, in view of it, in view
Yes,
of this
not
amendment,
Compulsion.
but here there is no compulsion. Rather, it is out of
Compassion.
Yes,
I'm using the word compulsion. It is not compulsion, it is compassion.
Yes, send it to the brother.
Well,
We are condoning the delay and equally taking up this matter and not interfering with the intro, the final order. In view of this.
What it says, madam, other that my case is to be considered as per 1990 rule.
Sir,
damn
whatever
it.
consecutive Bindu Sara case has been referred to by honorable single judge I will add to that, taking into consideration this amendment, they will dispose of and comply with the orders of the honorable single.
Yes, ma'am.
What more? Anything will be on. So by dismissing their application for condemnation delay, what you?
Madam, common.
Then I will be.
Yes. Item 26.
Just for 27. We saw.
Item 26. Remove that. SP Jana. SP sir. Item 26 memo is there for withdrawal. Item Item 27.
Confirmation, how much days? Chairman, you also have issued notice on 5th April 25.
Not delivered.
Not delivered, and I have also served a soft copy on the council which is appearing before only single judge. Is not appearing.
That means he is paying there, but not in sir.
Yes, madam. And I have also served a soft copy on the council which is appearing before only single judge. He is not appearing here. Rather, he is insisting the content.
This is one copy.
Soft copy on the council. He is not appearing here. He is insisting the
His
content.
name is not reflected, that's why perhaps.
I have also intimated. I have sent him a message. The matter is listed.
So we will do one thing.
My
But we will do one
sorry,
thing.
ma'am.
We will ask the registry to reflect his name in the past list on the next day, so that you know and come.
Okay, madam, that is my problem, madam. I know single judge insisting for
See,
complaints of that order, madam. That's why he's appearing for the honorable single judge.
Please, please serve him a notice again that this matter would be listed with his name as my brother suggested appear in the cause list, so that at least he has a notice.
And see the single honorable single judge order, madam. On 8/4 it was fixed to 29/4. So that matter was not listed 29/4, so we are saved from that reason. That's why our my learned friend is
How much days?
Notice was not served.
90 days.
Notice was served on
you are
25th.
representing the respondent there.
Yes.
Before the honorable single judge,
Yes,
right?
Yes.
That-
I will file objection to the petition for conditional.
90 days, man.
90 days.
What was the reason for?
Reason, madam, that your lordship, no, that's.
The lordship kindly
But-
have a glance to the region.
Able to tell you.
Yes, ma'am, that is the reason I
In a university, what are you talking about?
University.
Understand so far as a
In
garment department is concerned, but
Yes, this is the
university why?
Yeah, madam, that is the problem. Madam. Entire problem is for regularization of that post. There is no post of.
We are not entering.
Yeah, that's why we have taken the time and regularization of the post of artist. That government is not approving that post. So we are unable to regularize it. Accordingly, we have sought for clarification whether if that post is approved or created, that we can regularize. In the meantime, some time lost, we file late.
So you intended to comply the order.
Yes, no.
The moment you find that there is some obstacle which is coming in compliance, you find an appeal against challenging that order.
No, madam, that post is not there. There is no post.
For that,
Post
that
is not there.
direction was made both to the government as well as the university.
But here, even state.
Both parties were directed
Because there is
to apply the order
post with
as well as
we have the university. Unless the government says
That you knew Very well. From the judgment, date of judgment,
Yes, ma'am.
then why you kept silent?
That is yes, ma'am. I don't dispute that. That is our thought, ma'am, that in 90 days delay, your lordship, our some cost, we are ready to pay.
No, my lord, I will highly object for this. Last week your lordship has given
Reasonable
judgment.
cost, your lordship.
Last week your lordship has given judgment. This is the judgment.
Dismissing section 5.
Last week your lordship has categorically held the para 6. There is no quarrel to the proposition of law that the court should not be swayed by a length of delay, but must be guided by the merit of the explanation offered in an application for condonation of delay. The length of longer period may be condoned provided by the court finds the ground assigned in is coming within the purview of the sufficient cause, may reject the application for condonation delay of short period in the event the explanation is done.
That may be in respect of inordinate.
Yes.
90 days is not inordinate.
90 days, what is their explanation, your lordship? Kindly have a glance.
For 90 days,
They have only said para 1, judgment was passed on 15/7/2024 and appeal has to be filed by 15/8/2024. It is decided by the university to challenge the same and then appeal was filed on.
Where, what is this application? Which one? IA?
8103.
8102.
IA number
8103.
Yes.
8103. Kindly have a glass just. Nothing has been mentioned. And also Supreme. This is the
If this is
judgment of the
this is the summons
May-
of your explanation.
May I submit?
I am really at loss to find out the
May I submit?
submission cause.
May I submit?
Yes, please submit.
Well, I will not press that limit. Your lordship may give me liberty. I will file a better. I'll file a better limit. I'll not press that limitation petition.
but you have to see.
I'll give the reasons.
Please,
why it was not
5 of the limitation act, in my personal opinion, it's not maintenance because Odisha High Court rules specifies a petition to be filed under the so far as Senate appeal is concerned.
Yes, I'll file a better. I limitation petition. I'll file a better.
You file under section 5 of the limitation act.
I'll file a
The
better.
reasons may be
Yes,
same.
yes.
The criteria.
Yes,
for consideration
I
is
understand.
same.
I understand.
There it is good reason, here it is sufficient reason.
I'll give the sufficient reasons. Will better limitation. I'll file a better limitation.
one after another they will file another better application, another better application, it will be entertained.
As my brother
Mr.
pointed out, it
Mr.
was under the
Mr.
wrong provision.
Mr. Counsel, have you gone to living media? Court has given many opportunities for filing.
This is the judgment of the apex court,
Yes, 2013 Supreme Court.
2012 Supreme Court. Clearly it has been mentioned.
2013 Supreme Court has said that their lordships have given opportunity to the council to file better application. And despite that opportunity, the council repeated the same thing. That's why living media has come. Read that judgment properly.
I will file show cause, ma'am. I will file objection.
So he is not pressing.
I am recording. The counsel for the petitioner submits that the instant application for confirmation of delay contains a fatal defect. Having filed under section 5 of the Limitation Act, although there is a specific provision provided in the rules in this regard. So, according to him, such fatal defect is incurable in nature and prays for withdrawal of the same with liberty to file afresh.
My submission will
The counsel for the opposite party.
number 1.
Vehemently opposes, I was getting a better word for this. Vehemently opposes such prayer since the writ petition, since the application contains a fatal defect, we do not find any impediment in permitting the petitioner to withdraw the said application with the liberty to file the same. Accordingly, the application being IA number such and such is permitted to be withdrawn with liberty to file a fresh application within 7 days from date. It goes without saying that the copy of the said application shall be served upon
Opposite party number.
No, you tell me.
P.K. Mahathir.
Are you an advocate and record? You who will file Vakanandama?
I have filed.
Upon Mr. Mohanty, who is appearing for the opposite party in the instant battle. List.
My submission,
14th May.
the filing of one after another petition for condonation of delay.
This is the first application he has filed. Earlier he did not.
No, he has not filed, but subsequently
that is a frequent.
When it is going to be dismissed, he is saying that I will file better application. It is not maintainable.
The condonation.
I will file in this regard.
Yes, call the
Item.
Respondent number 2 in this.
State.
Last.
You waive the service and you appear.
Government is ready to comply the order. Well, direction to both parties. If government is ready, as well as the government. If government
in
the contempt application we have submitted that, I am ready to comply the order.
If government is ready, we don't have any objection because we are the university.
Votes are not available.
If the vote is dictated by the government, we have to regulate.
Yes.
28.
Item number 28, and for the appellant, because there is a delay of 62 days in filing the writ of petitions.
Notice or condonation application. Yes, next.
Item 29.
Same for the appellant. In this matter, the notice has not been.
With the endorsement left.
I'll take steps to obtain the refresh address.
Application. Plus steps to take a press.
Item 30.
The present writ appeal is before against the impound order passed by the single bench of this Honorable Court. HARISH order dated 20/12/2024 in dismissing the writ petition having serial number 80,348 number 2023 on the ground that
The writ petition emanated from civil suit.
No, civil suit is different footing.
But what is your remarks in the writ petition?
To issue the rule nisi against the
Rule nisi is a different concept.
here
What is your prayer in the writ petition?
to restrain the action of the opposite parties who are the respondents. They have not been included in the suit. They are the out of suit. They are parties in the out of suit, and they are creating all sorts of disturbance over the suit land. In absence of any prohibited order passed by the civil court, they are creating also disturbance and your lordship at first the single bench passed order please kindly see order dated as 23rd 6/2023. Just I am perusing the order. Had long counsel for the petition or notice to the opposite party by registered post with AD, and for the said purpose, long counsel for the petition shall file requisites within 3 working days. List on 14th July 2023 for appearance of opposite party and further order. IA, your lordship, what passed order in IA, the restraint order was passed by the court by the single judge to restrain the to maintain the status quo by the parties. But during pendency of the writ petition as well as the IA, they took the law into their own hand and removed the construction,
technicians of the houses, the temporary houses, asbestos houses, overshooting by using force and ultra-virus power. Then the contempt petition filed. Said contempt was dismissed.
The contempt was dismissed. Then
Contempt petition was dismissed in absence of a petitioner. And then subsequently, when the matter listed before this the said court, in order to adjudicate the matter through its impugned order, court below did not apply its decision under regarding question tenability. On the regarding question tenability, that matter was disposed.
you have already filed a civil suit.
Yeah, nothing.
The civil suit is pending.
Civil suit.
Now,
civil suit pending in respect to suit settled property, but who are implicated in the court below? They have not implicated in the suit.
I am talking about, is it in relation to the property which is included in the suit?
Property
is one and the same.
Property involved.
One and the same, which is also involved in the suit.
Yeah, that's it.
Now you have filed a suit.
Yes. I have filed suit. In respect of
you have a freedom. You have a freedom to implead a person as a defendant.
Your Lordship,
you can implead any
there
person
is no,
against whom you want.
Your Lordship, please kindly see that I am just submitting, just in a briefly, I am just submitting, not by enhancing the letter of the gate. At this stage, what happened? The writ petition. They are not impleaded in the suit. They are the
probably you could not get what I have said.
Yeah.
You are a plaintiff.
I am the plaintiff
of that suit.
No, in that suit.
You have a freedom to implead party as defendant.
Now, your Lordship, please kindly see whether the said writ petition tenability, question of tenability got dismissed by the court below, by the honorable single judge.
So
whether during pendence of the suit, by impleading another party and outsiders, whether the writ maintainable or not, that without giving any opportunity, without calling for any show cause from the opposite parties, here are the respondents, simply the past order dismissing the writ petition.
Under Article 227.
Your Lordship.
Under Article 227.
226, Your Lordship. I have not sought for in the original in the single bench under Article 227.
226 or 227?
226.
How can that?
It is maintainable. Question of tenability without hearing, without giving opportunity, without calling for the LCR, whether question of tenability here arises, whether they said a particular writ maintainable or not. Without giving any scope and opportunity, without calling for how the court below came to the conclusion and that the question of not maintainable and got dismissed, showing and relying the particular case in respect to the land, whether the civil suit is there in the competent court, civil court. And accordingly, without examining anything to that effect, whether question of tenability or not, at least they should giving any opportunities, mere opportunity to the petitioner after hear the matter. Then at least notice we.
That's all. Anything more?
No, Your Honor.
Yes. The instability arises from an order dated 20th December 2024, passed by the single bench in the writ petition number such and such. Wherein the writ petition was disposed of as the petitioner class opinion has already approached the civil court. Raising the issue involved in the instant writ petition. The counsel for the appellant submits that the writ court should not should not have proceeded to dismiss the writ petition on the ground that the civil suit is pending, but should have directed the notice to be issued and an opportunity is given for hearing. It is further submitted that the private respondents in the writ petitions are not arraigned as a party in the civil suit, and therefore the writ court could not have dismissed the writ petition on the ground that the civil suit filed by the appellant is pending, and therefore the court cannot hold that the writ petition is not maintainable. We appreciate the agony and anguish shown by the appellant on the dismissal of the writ petition at the threshold. But equally, we cannot overlook the fact that the writ court may refuse to exercise its discretion. It is not an absolute principle that the moment in law that the moment the writ petition is filed, the Constitution Court is bound to issue a notice and cannot proceed to dismiss the writ petition at such a stage. In the event the writ court finds that no legally enforceable right or infringement of a constitutional right or a fundamental right or a statutory right is pleaded, there is no fetter on the part of the writ court to dismiss the said writ petition at the nebulous stage of its filing. We therefore could not persuade ourselves to agree on the proposition that the moment the writ petition is filed, the notice is inevitable and the court cannot dismiss the said the writ petition at the threshold. Next part. It appears that the appellant is beleaguered between the maintainability of the writ petition with the entertainability of the writ petition. The writ petition may be maintained, but the court may refuse to entertain the same by providing the reasons. There is a gulf of difference between a maintainability and the entertainability. And therefore, the contention of the counsel for the appellant that the writ petition is dismissed as not maintainable does not appear to be a correct state of affair, as we find from the tenet of the order that the writ petition was dismissed as not entertainable. Stop. Furthermore, next paragraph, the appellant has approached the civil court by filing a suit claiming his right in respect of the property, which is also a subject matter of dispute in the writ petition. The plaintiff, being a dominus litis, can implead the parties as defendant and cannot segregate or dissect the parties in different proceedings. If the common issues or if the infringement of right is common to several persons, they can be impleaded as a party defendant And if the petitioner, if the appellate has left out the present private respondents to be impleaded as defendant therein, he cannot take the benefit thereof. From whatever angle we look at, we do not find the ultimate decision taken by the single bench in refusing to entertain the writ petition on the ground of an efficacious alternative remedy having already exhausted, and therefore the instant appeal is dismissed.
Your Lordship, just a reminder of decision of the Honorable Apex Court reported in 1980, Rani Lakshmibai Kshatriya. Rani Lakshmibai Kshatriya versus
which one?
The petitioner named Rani Lakshmibai Kshatriya.
Lakshmibai
SCC reported case. Rani Lakshmibai Kshatriya versus I don't know.
I remember the Whirlpool India Limited judgment of 1998 of the Supreme Court.
Supreme Court SCC reported 3 benches.
Also, yeah.
Question of tenability. They have already decided question of tenability. And here, another case.
Tenability or maintainability or
preconditions. Question of alternative remedy. Whether maintainable or not.
It admits no ambiguity on a settled proposition of law that refusing to exercise discretion is within the domain of the Constitution Court, as it is not a rule of compulsion but of discretion. The moment the single bench exercises discretion in not entertaining the writ petition on the ground of alternative efficacious remedy, it is not open to the appellate court to interfere with such discretionary order unless such discretion is exercised unreasonably, irrationally, and in violation of a settled the parameters of law in this regard. Anything more I can add?
Your Lordship, just I submitted the before the Honorable Court. In that case, Rani Lakshmibai Kshatriya, in that case, the Supreme Court has categorically stated normally at the threshold, the writ petition cannot be dismissed here. And
So we have
throw out into the first bit.
now there has been an evolution of law subsequently.
I have right to submit at the threshold.
Urgent photo state certified copy if of this order, if applied for, be given to the appellate within 3 days from date. I think
Your Lordship,
it's better. It's better.
Your Lordship may kindly see.
Item
31.
Your Lordship may kindly see. Just as an officer of the court, I have a right to submit before this court. And as of now, I have not given any opportunity to hear the matter regarding question. If the court moves to more satisfied, then another date may be fixed. No, sir. And no, sir.
Then should I record this? Should I record? Yes. Then we'll have a cascading effect, sir. If you say so,
I am ready to. Don't your Lordship take otherwise because
no, it's not taking
because I have a right to put before this court regarding.
Mr. Counsel, please realize it. You have ignored one aspect. You have no proper vocalization of right. They are not executed by your parties. You have your clients. You have no authority to submit.
I have my power is which is the original application. No advocate.
Continuation, sir.
Sir, no. I am there. I am there in the original writ petition.
For fresh vocalization.
That is sir. That is the
execution of your part, your client.
That is the technical issue, not a substantial
cost, sir.
No, sir, I am ready to file. No, if he not filed, then I am ready to file. That is not point. Point is to be noted for the question of tenability.
I think
issue.
Only
sir, my question is very specific.
Criminal procedure code or now in the PNSS, there is a provision for postmortem. I think in the Constitution, postmortem of a judgment already dictated and delivered in the open court is not quite evident. As of now, I believe so. So please
Nice.
consider this,
Yeah.
because the postmortem after the judgment is delivered in the Supreme Court.
My lord, leaving aside all those things, few months back only, there is a judgment of this honorable court that High Court rule permits a case to be dismissed at the threshold. It cannot be allowed without giving notice.
There cannot be a law
My lord.
that cannot be dismissed.
That's what I'm saying. High Court rule permits it.
If they want, I can also give some courts of judgments of the Supreme Court.
At least your lordship.
But anyhow, we do not want to go into that aspect. We have already said so. So we have also directed the very short date within which the certified copies be given to you. Please.
Item 31.
There is delay in filing the appeal matter.
How much delay, sir?
110 days.
How much?
110 days.
Obviously, I having not been served on me, I be in a position. No, that's not so. Entire day, in actually 11, 19.
Oh,
We have not given that copy. I am not in a position to know. Let me run it and take back of the
Serve him a copy.
Yes.
That's the matter to be listed.
On 7th month.
Because of my.
Sir.
Then he
Getting.
Eight.
Explanation.
8th.
If he appreciate you have a difficulty. Eight.
No, no, sir. 12 my niece is getting married.
Yes, sir. That's congratulations. All the best for her. Yes.
Item 32.
There is a delay of 19 days only.
What you say, sir? 19 days.
No, it's not 19 days. You kindly see the application.
The-
87 days
Which one
delay,
is?
they themselves have treated with the
32.
application.
Huh?
They themselves have stated in their application.
That is our staff reporter, what is that? Oh, there's something more.
My
Another
lord,
25 days, our staff reporter said.
and interestingly, your lordship will look at para 2.
1182. 82.
The lordship would kindly look at para 4 of the application, the only explanation given. Whether there is sufficient cause given, the lordship will kindly see. Issa Bhattacharya and other judgments, 2024 Supreme Court. I'll cite those through the rest.
Justice Pankaj Mittal's job.
Right.
That's specific period also you have to.
Kindly see, yes, Lord, kindly see para 4. The lackadaisical way of dealing with the matter. Yes, you have to show sufficient cause. Kindly see para 4. Judgment was passed on 28/10/24. Then so and so. Then we contacted our Advocate General's office on 5/2/25 for filing writ appeal, and writ appeal was filed on 21/2/25. It is an explanation at all.
I will also rely on only one judge, the Supreme Court, that I have quoted para 37 of that. Shivraj Singh's judgment. Para 37 is the only answer to this because if my lord allow me, I'll just place that paragraph only. That I have quoted in my IA application also. Having bestowed serious consideration to the rival contention, we feel that the High Court's decision to condone the delay on account of first respondent's inability to present the appeal.
There are other documents, this says that the government is not a frivolous litigant.
Well, I understand.
Section 5, it is at par with another individual. If an individual cannot get away with such explanation, why the government?
24th Supreme Court says that irrespective of liberal approach, you have explained.
Very difficult proposition. Very difficult proposition.
Correct.
There are larger bench decisions prior to the same, which says that the court may also look into the merit. And meritorious matters should not be dismissed on the ground of libel.
Correct.
24 judgment says no merit should be looked into.
No, 24 doesn't say that. 24 says kindly see.
Is it Justice Patiwala's judgment or Justice Mittal's judgment?
24 is, my lord,
Justice Mitra.
Look at the last one,
Right.
the paragraph. Yeah.
Right.
1, 2, 3,
Kindly
4,
see
5,
this.
6. 1, 2, 3, 4, 5, 6 in jotted down. Please see. Merit should not be taken into
The
consideration.
Lordship has gone into the judgment. Kindly see, Lord. At least.
I'm not seeing where he has the author has jotted down.
Yes,
Please look. One of the ground is merit should not be looked into.
merits of the case are not required to be considered.
This is what I hear join an issue.
Right, Lord. That there are other judgments, 2013 Supreme Court, while considering the question of delay, merits is also to be looked into. I know, Lord. I know that 2000, that's a Deepak Misal judgment, 2013 Supreme Court. But sufficient cause has never been dispensed. If your Lordship and all of us will agree, sufficient cause.
Indispensable, no doubt.
Right. Now,
sufficient-
looking at para 4, if your Lordships are satisfied that there is any cause given from 2810 to 52, not a single cause given month. And what is the case here? It's a case of regularization. 8 persons you have regularized and the 9th person. Finance department has taken a decision to regularize me. So look at the finance department decision. Law department has
don't take it as something from us because you are representing the government. You also represent. You cannot.
Yes,
That's your responsibility. There are certain states, they have adopted a litigation policy. If a particular point has been decided by the court and tested up to the Supreme Court, then, and the plea of defense taken by the government has not been accepted, then they have adopted a policy that that defense will not be taken,
right.
just to continue with the litigation.
Yes,
and the government will accept what is. Similarly, if in a regularization matters, if there has been a consistent view, yes, and in some cases the government has already accepted the order and
not only government
given a effect there, then why in some of the matters there will be a litigation?
In case of the petitioner, finance department has decided to regularize. Kindly see page 7 of my objection. In case of this judgment, their own department and law department has said to regularize.
About
then bring it to the regular.
about this
And they have given me regular salary.
About this case, I'm not saying anything. The Honorable Chief Justice said. That when a decision has already been taken, why to repeat those? Actually, the lordship knows in course of 2-3 months only. All rehabilitation matters, RSP matters. The government has taken a decision. So that thousands of cases are becoming informational disposed of. So our government is taking steps in this regard. About this particular case, since I am not holding the
steps, I am not putting on that. I was just thinking about the litigation policy. There must be a litigation policy. Suppose you have raised, government has taken a particular plea as a defense, and this was tested up to the Supreme Court, and the Supreme Court has not accepted it.
That will not be repeated.
Then
Yes,
that should not, because I have an experience there. Frequently, the same. They have a set of the arguments. They have a set of the counter affidavits, and just 2 paragraphs of that method and cut and paste there and the last. And if you say I am submitting a written notes of argument, voluminous, same judgment, same citations, same averments, do it. That is why I was just thinking about it. Sir, delay.
That's fine. But kindly see parasite, page 7 of my objection.
Show them on merit. Show them on.
Can be taken up right now, Lord. Otherwise, this man, 9 persons appointed, 8 got regularized.
This is what it really affects me to some extent.
And
you are chosen to regularize or appoint somebody there. Why is
Not only that, pursuant to the judgment passed by this honorable court, they have allowed me regular scale of pay from the date of my initial appointment. They have complied with the judgment. They have given me the regular scale of pay, my salary, revised, everything. Once they have given me the regular scale of pay pursuant to the judgment, they have accepted the judgment. Kindly see that judgment below passed by this honorable court, page 161, 165. They have accepted my salary, everything. Only question of formal regularization. It's a close. Only thing is not those other persons, they are creating a bottleneck so as to protect their seniority. That's all. Otherwise, government is not interested here.
On merits, you
Government is not interested here. Government, kindly see page 7 of my objection, my lord. I am reading it. In view of government policy decision, while as a one-time measure, services of similarly placed employees have been regularized, the petitioner has been treated differently. Therefore, the honorable court have given direction to regularize services of the petitioner. In that view of the matter, no scope to challenge the judgment. So and so may be advised to comply with the same. This is finance department is saying. In my case, this is the case. And kindly see the law department opinion. I'm sorry, that law department. I read that the law department, page 9. Finance department say, finance department has no objection if the AD decides to implement the court order after taking government approval. But if two of your departments say that regularize.
But those documents are not on record.
On objection I have given. Along with my objection I have given to him. These are all obtained on RTI.
I'll have taken instruction on this.
It's only victimization.
Yes.
Right.
If you have given some, you cannot leave others.
And your worship judgment, sitting single, I am not giving that. Those tax, yes, temporary employees in that GST. Grateful.
Income tax department.
Income tax
In some cases where the state has implemented, that is in view of the dismissal of the appeals and dismissal of the SLP on the basis of delay, the state has implemented, but that will not be a precedent for other cases.
That means, should I take it in that spirit that if in this case also the dismissal of the appeal is there and the SLP is the implementation, otherwise not.
Now my learned friend has raised some point, my learned senior has raised some point that under the government there is some concession with respect to implementation of the order. Let me take instruction on that.
Take instruction, because I find your application says it's the government of the water resources.
Yes.
Department.
Yes.
He has taken a decision to go for it.
Yes.
The finance has
The nodal department
the law department
is only a consultant department.
You can't. Then how that water resources department will take a different view?
No, my lord, water resource department is the nodal department with respect to implementation of the order. They consciously took a decision. So far as law department is concerned, that is only a consultant. They will take consultant from the law department that whether to go in appeal or not.
If any problem relating to law is concerned, the consultation is there. And if the opinion is expressed, then overriding the opinion, there must be a very convincing material.
Not only convincing, approval from the chief minister, which have not been obtained here. Rules of business say that. They have not obtained approval from the chief minister. Rules of business clearly says that.
What to take instruction?
I'll just take it.
Let him take instruction. We are keeping this matter on Monday. Right. Sorry, Monday is a.
So this side.
Oh, Monday is.
Maybe.
No difficulty. Fifth.
Grateful.
In course of the hearing, for the party, senior counsel for the opposite party submits that they have relied upon the documents which forms part of the annexure to the counter affidavit filed in connection with the condonation application. Therefrom, it will appear that the finance department has accepted the ultimate the ultimate direction passed by the single bench. Semicolon, sir. Even apart, the law department, the law officer of the government department has also acquired to implement the order, but ignoring the above, the present appearance plan. The additional government advocate submits that in view of the subsequent development having disclosed the said application may be listed on the other day to enable him to take the appropriate instructions. This is the matter on fifth.
Yes.
Great. With content you have submitted. Content.
Yes.
The content is dropped on the
ground that the contempt is direction for that to implement.
The order taken, the order in WPC number so and so has not complied with. The contempt petition stands disposed of with the direction of the opposite party.
Comply with this.
Comply with this same.
Yes, yes.
Within a period of 2 weeks from the date of receipt of the copy of this order.
Yes. They have
So
not
you have
filed.
prepared a writ appeal after that.
Or against the parent order.
Parent order, but in contempt.
Contempt matter, all the contempt matters in the first attempt. Here in this court, first contempt matter.
Unfair.
This is the, your lordship knows it. Possibly your lordship must have.
Knowing something is different from
Although
your unfairness.
doesn't allow the two contempt application to be filed, but it is the court.
My lord's
practice.
my lord's point is.
That
Yes,
is
I understood
mistake
that.
committed by the court by granting you further time.
Yes, and you are not challenging this.
We have committed by granting you time, further time to comply.
So that various cases will be disposed of outside court. That was the purpose. So that several cases will be disposed of outside court.
Correct.
So
Pendants will be
so
lessened.
now on we should not grant you further time. Contempt direct. That should be problem.
Possibly I couldn't express properly.
Don't express.
Possibly I couldn't make your lordship understand
Sir, in
what was the.
original restriction disposal judgment, whatever is given, if you don't comply,
That amounts to contempt.
there will be contempt.
Yes.
We will not accept the grant you first contempt, second contempt.
That cannot be second opinion, my lord.
That's what you are pleading.
Item 33.
30.
The writ of 33. The writ of this has been filed for the delay of 13 days.
How much days delay?
13 days.
213.
8 months already passed. 8 months already passed. The WPCOI number 365, 2018, which was converted to WPCOI number 3, we submitted the Honorable Single Judge that was pleased to dispose of the petition on 2/7/2024 by passing the entry order and disengagement with the direction to the collector, respondent to collector Cutter, to issue an order of reinstatement within a period of 3 weeks. Thereafter, the respondent filed a contempt case number 7313/2024. In this honorable court, the honorable court single judge bench was pleased to grant 1 month time the state appellant to comply the said order on 2/7/24, filed their order number 27/1/2025. Thereafter, the respondent filed another contempt case number 12/06/2025. That's why I'm contesting that also delay 13 days.
The order was passed on 2nd of July 2024. It was been filed by 1st of August 2024. Admittedly, there has been a delay of 213 days. For that, I have filed that interim application. You also will find that very same judgment has been reflected. What my Lord Chief Justice was saying, it's correct. That same judgment has been taken report through, and my learned friend has given a reply. In his reply, only thing I'll point out to your lordship that he has said deliberate, willful, and intentional delay. That is not correct, my lord. Deliberately,
Your Lordship, I have already filed contempt case number 731
yes.
That is the opposite party taking 1 month time to reinstate the.
No. He didn't take 1 month time. That is the order passed.
Order passed.
Honorable
That is-
Court
that is
granted
the-
this much of time to implement the order.
It's
That is not on our prayer.
The court's order, you don't,
No, court has-
don't complain.
I don't should know. Court has passed an yes.
Deliberate. That itself is deliberate.
Deliberate for
That itself. After second contempt, you decide to file with appeal. Is it not deliberate? Attempt to harass him.
Respectfully, I'll submit my lord, not with an intention to harass. It is because your lordship knows in government level these things.
We never know anything. We don't know. We know only the judgments, directions given, whether complied or not complied.
That
How
is,
you function.
I don't dispute those things.
How you function with your list work.
Correct. To that extent, correct. What I was submitting, my lord, that it is a practice, my lord. From table to table, it consumes time, which has been also taken note of by the Honorable Supreme Court in 1 or 2 judgments. Since government level, little bit of delay occasionally occurs. That has been taken note of in some judgments.
This is slapping on our own face.
Well, you also feel that way too. That is never my intention to say that. The observation of Honorable Supreme Court in some cases.
Yes, ma'am.
I was a party to that judgment with Justice Kaushik Chandra. Justice Chandra authored that judgment on Section 5. There. I think whatever Mr. Das is arguing is taken care of in that judgment. Bring that judgment. I am bound by my own decision.
I'll try to look at that.
It's a division bench comprising of me with Justice Kaushik Chandra on Section 5 of the Limitation Act. Delivered sometimes in 2023.
My lord, I'll look at it. I'll get a copy of that.
Keeping this matter on Monday and then.
Respondent is going to return today, my lord.
And that's why going
No difficulty. Ask regularization
Yes,
from
yes.
the
I
immediate
know.
effect. If
I-
likeness
yes.
notified, if the
This bit
section,
appeal, I-
suppose, if the section 5 is dismissed today, that means the appeal has to go, then what? And if the section 5 is dismissed on Monday, the appeal has to go, same thing. How it changes? Regularization will take effect from a retrospective date, no difficulty. Or in terms of the order of the single bill. It's Monday. Find out that judgment. No.
For admission item 35. Fine.
On behalf of Madam Jena, I'm going to take up next, please.
On 16.
Item 6. Item 36.
36. You also hard matter extensive. Question of that. Also correct, but that's all I best. No, I never say no. I say list matter. Learn to adjust both of my reach appeal. Just and particularly. Yes, 47. There is a so-called notice issued by the Staff Selection Commission. I'm appealing for Staff Selection Commission. The so-called notice was issued to the candidate those who have received malpractice and misconduct for getting access to the question paper prior to the examination of junior engineer civil was conducted. Because of that, a so-called notice was issued and the
reply was given.
And reply was given. When after giving the reply, a writ application was filed challenging that the two writ applications earlier was filed. Last case, the writ application was filed challenging the cancellation of the examination itself. First initial examination was conducted because of leakage of question paper. Information was received from the SP Baleshwar. On the basis of the information received, that examination was cancelled. So some of the students filed an application challenging the cancellation of the examination. And thereafter, the examination was rescheduled. Some writ application was also filed to allow the students to appear in the second examination, anticipating that they may not be allowed to appear in the second examinations.
Where is the impugned order?
Impugned order is at page 166. Page 166. Here in this case, what happened? The impugned order, the one single judge has
Leakage of paper. Leakage of paper.
Yes, leakage. They say
Confined to leakage of paper. The person responsible.
yes, leakage of question paper and getting access to the question paper. And ultimately, it is held that the petitioners are no way connected with the leakage of question paper, but in the operating of the
They
part.
access it.
My lords?
They have accessed it only.
No, that has been held. But when the direction was made to consider the so cause, the direction was made if petitioners are no way related to leakage of question paper, then that proceeding is to be done. So it is ultimately held by this Honorable Court that petitioners are no way connected to the leakage of question paper.
No.
Yes, that is the direction. You also can turn to paragraph 9. Paragraph 9. Page 168. 168. 168 is in place. On careful examination of the affidavit filed by the IO, this court is of the prima facie view that the petitioners were party to the second part of the occurrence. Second part of occurrence means that is access to the question paper. So the petitioners are getting access to the question paper. It is held.
Therefore, it is also observed.
The prima facie finding which was returned there, the prima facie finding.
Yes.
If something is found at the investigation that
Yes.
actually you were involved in the leakage,
Yes.
then in that event, why not the authorities would really take the steps? So that let the investigation continue.
Yes, I am not on that one. I am for the staff selection commission. We want
Here the other side.
Other side is here. We want to proceed against them. So, sir, yes, my submission is we want to proceed with the against the police.
Because see,
Yes.
it is at the show cause stage. It is at the show cause stage.
Yes.
So in the show cause stage, let them take a decision.
Yes, I don't stand in the way. Let me look to the judgment of the Honorable Single Judge. Let me look from paragraph 4 onwards.
The only thing is paragraph 9 has to be clarified by us.
Yes, sir.
Saying that it is a mere prima facie finding.
Yes.
Investigation will go independently.
Yes.
And if it appears that there has been a leakage and these persons are also involved in the leakage.
Yes, that will start with. Yes, sir. Yes, sir.
That's what I want. That's what I want.
They want to go.
So we will proceed with the so-called notice and
Who is for the writ petitioner?
We are for the request.
So
this is a writ appeal.
This is a writ
Writ appeal. This is a writ appeal.
Yes.
I am very conscious. When I ask who was the writ petitioner, means beneficiary of this order, I just wanted to hear him. The appeal, sir.
But can you actually look
what the beneficiary says?
Yes.
We have to hear.
Kindly come to paragraph 10. That's all. That's what your worship says. That is in the aforesaid factual backdrop, this court permits the IO to continue with the investigation with the direction to conclude the same as expeditiously as possible by covering all
angle of
conspiracies.
Yes.
Yes.
Yes. Then why you are?
Again, also kindly just Mr. Further, this court also, please, Mr. Further, this court also direct the OSSC, present appellant, to finalize the proceeding initiated by issuing a so-called notice to the petitioner, to which the petitioner already filed the reply.
Correct.
In the event, it is found that the petitioner are in no way involved in the leakage of the.
Yes.
That's right.
So is there?
That's right.
The event.
That's right.
No. Actually, in the previous paragraph 9, the observation is that they are no way connected. The observation is that. The observation that observation is. Only that observation
is clarified.
That's very correct.
From the submissions advanced by the respective counsels, the point involved in the instant writ appeal is hovering around or revolving around the construction of the language used in paragraph 9 and 10 of the impugned order. To stop. Both the parties have interpreted and construed the language employed therein in different manner, causing an uncertainty in the course of action in terms of the ultimate directions passed in the impugned order. The initial dispute pertains to the leakage of the question papers.
And getting access to the procedure.
So some leakage issue.
With deepest of respect, I think
With all respect,
I think the judges on the bench has a freedom to dictate the order in their own language. And I think if the member of the bar feels, I think this is better to give a suggested order so that we will simply give a nod to that suggested order without application of it. I think that freedom has to be respected.
It should not.
Go in our foreign language, sir, is a medium of expression. One may express in a very simpliciter way, one may express in a complex way. So it is all depend upon the grooming which a person has in his life. So I think let it be.
I will also proceed.
Yes.
The initial dispute pertains to the linkage of the question papers.
Papers. And an access to it, which was unearthed and not detected subsequently. The conscious decision was taken to scrap the entire recruitment process so as to avoid any benefit to be availed through an unscrupulous manner. But still, the ball continued rolling in the court as the opponent decided to initiate a proceeding against the respondents / opposite parties in the instant appeal and issued a show cause notice upon them. Though the reply to the show cause was given by the respondent of the part, but they challenged the show cause notice by filing the writ petitions, which were taken up together and disposed of by a common judgment. The single bench have dissected the issues in two compartments, namely the person involved in the leakage of the question papers, and secondly, the persons who got an access to the leaked question papers. In pursuit of the same, certain observations were made in the impugned order, which is understood by the parties in a different manner. Stop. The appellant appears to have understood the purport and the tenet of the observations made in paragraph 9 as sacrosanct, leading to an absurdity and or uncertainty in compliance with the ultimate directions passed by the single bench. On the other hand, the single counsel appearing for the writ petitioner respondent submits that there is no confusion and or ambiguity in such findings as paragraph 9 and 10 of the order is to be read conjointly and conveys a laudable intention of the learned judge who disposed of the said retribution. The appellant still insists that the observations made in paragraph 9 has foreclosed the doors of investigation doors of the allegation against the writ petitioners in relation to a leakage of the question paper, and according to the single bench, the same is restricted only to an access to a leaked question paper. Before we proceed to appreciate submission, it would be profitable to quote paragraph 9 and 10 of the impugned judgment, which runs thus. Quoted. The language used in the aforementioned paragraph leaves no ambiguity that the court refused to interfere with the show cause notice and directed the authorities to proceed in investigating such serious issues, and it does not appear prima facie case is made out for involvement in a leakage of the question. Such observation is tentative in nature and cannot receive any sanctity as susceptible to a non-interference at the investigation stage. The observation made by the court expressing the prima facie opinion is never regarded as final, which would further be evident from the observations made in paragraph 10 of the impugned judgment, wherein it is held that in the event the writ petitioner respondent is found to be in no way involved in the leakage of the question paper, then the proceeding should be dropped. In such view of the matter, since the observation of leakage of the question paper and its involvement is still left open to the investigation officer, we do not find that such observations would create an absolute brindle and or fetter on the part of the authorities in deciding the issues in accordance with the statutory provisions applicable in this regard. We thus do not find any ambiguity or to speak of impossibility of reconciling the observations made therein, and therefore the instant writ petitions appeal is disposed of.
37.
Filing the regional
in this matter, some contempt public contempt petition has been filed against the Staff Election Commission, saying that the result has not been published. The result was not published. This is not only we will also fix up some date within which we will close the proceeding. Analyze the proceeding.
We don't know, it is not before us. The contempt is before us.
No, contempt before the single judge.
So let us go and convince the single judge. I believe you be able to convince him. Not ultimately your losses on
37 Just now, my learned gave a copy of the result.
Just one question is involved, only the factual aspect I have said.
Yes. Yeah, right. What he says.
Just now, my learned gave me a copy of the result.
You want to peruse?
Yes, Paolo.
I have. There's a right to peruse.
Next week, minus
Monday.
Yes,
Monday.
I have. Interim order to continue. Interim order,
Whether there is an interim order.
interim order is there.
Is there?
Interim order is there, by the way. Interim order has been passed on 11 to 2025.
Oh, till the next week.
Okay. And I have taken applications for intervening interim order.
Interim order.
It's not the copy on both.
I have already found the
So
copy.
intervening application to be listed on film.
Item 38.
Here in this case, the huge area of government land given to the opposite party number 18 for industrial purpose. Now they are trying to dispose it of by selling it, taking it as a Stitivan land. And this honorable court and the government has filed a counter. They are taking steps to the collector himself said in his counter, and have a glance to the additional affidavit filed by the collector. Dated 11/12/2024.
Give a state for that.
Let me, I am for the petitioner.
Yes, please. If the merit is taken up, it will take some time. In fact, an order of this honorable court was challenged before the honorable Supreme Court. And
Which
just
order?
that order of 19th of
19th
19th March was challenged.
February. 19th February order.
Yes. That was at flag you know,
So what has happened to the Supreme?
there the honorable Supreme Court has in the last order has said that pendency of the SLP. I'm just reading out flag
Flag
a flag
flag key, additional affidavit.
Yes. Ratio.
5 is that page 4. S by 10, page 4, Malad.
Yes, right then.
Not to- However, pendency of
The pendency will not stand in the way of deciding the interim application.
interim application.
So the main cannot be decided, but interim can be.
Yes, but we have filed an interim application for vacation of state.
No,
For vacation of the interim order.
you
That application.
they have
I
not
want-
sought
I
the
want-
additional copy, not sought on me. Additional copy they have not sought. But the honorable apex court said will not come in the way of the High Court in deciding the interim application or the writ application. The honorable apex court said. And here the government has filed the additional affidavit. Government has filed the additional affidavit. There is completely illegalities in granting this land and they are trying to cancel the lease and kindly have their additional affidavit 11/12/2024.
I'll just say, these three sentences.
They are private party. They have
These
no right to claim.
sentences.
Why they are not? If they are affected by any order.
Yes, we have made them party.
So
We have made them party.
why you say that they have no right? He understands what you wanted to flag.
Yeah.
You wanted to say that certain things have been done which should be made known to all and the sundry. That what is enough.
Yes.
The government has found that there is some illegality has been committed. They are trying to take steps
Yes,
to
Your Honor.
remedy those
Yes.
illegalities.
Absolutely.
So why they will be affected? Let us see that what right they have.
I'll just say, please.
Let them sign the additional affidavit, copy.
Allowed these sentences only, madam.
Only 3 sentences I am allowed to speak. In fact, there was a section 7 application before the NCLT. Section 7 IBC before the NCLT. The resolution plan was accepted by NCLT. And the resolution plan specifically said that the
resolution proposal has been there initially. It was not
yes, resolution.
And then the resolution plan is accepted.
Resolution plan accepted.
Correct.
The matter carried to NCLT, NCLAT.
Correct.
That was dismissed. And then matter was carried to Honorable Supreme Court. Honorable Supreme Court did, while when issuing notice, did not even accept that the NCLAT or NCLT order is banned. It only confined to the right of Edelweiss as to how much they will be getting. The Honorable Supreme Court only confined the entire result to that fact. Or else rest of the finding of the NCLT and NCLAT has attained finality. In the NCLT proceeding, I was the resolution applicant, successful resolution applicant, and my application was accepted. Plan was accepted. It went to NCLAT. NCLAT also accepted my plan, and the approach to NCLAT was dismissed.
What happened to the creditors?
In fact, Lordship put a very pertinent question. The resolution plan specifically states that the land to be disposed of and the revenue getting generated will be paid to the creditors. The specific
so the outgoing company could have done the same thing. What is the new in the resolution?
Well, in fact, the first was the company.
How much money you have decided to infuse into the company outgoing concern or the outgoing company and liquidate?
Initially, this is a checkered history. Initially, there was a company here. That is Titagarh Paper Mill. Titagarh Paper Mill has 2 units in Kolkata. One unit.
Is it relating to Titagarh Paper
Yes,
Mill?
yes, madam.
Huh?
Yes.
It is relating to that?
Yes, yes, madam.
I am releasing online now. I happen to be a counsel.
But Titagarh, I'm sorry, just but what happened? Titagarh Mill matter went to
It's a JP Chaudhary's company. He happened to be my client. I do not know. Yes, it is online.
But now it is.
Since one of us
wanted to build, and now
since one of us give my name within the bracket, does not intend to take up this matter on his personal ground. Let this matter be released from this bench and be placed before the Chief Justice or assignment to any other school.
Status quo to be continued. This is till today.
Decided it will be done.
This is till today.
Sir, with folded hand, when one of us has decided not to touch the matter, then he will not pass it. So it will be there, you go before the regular.
Let it be listed on Monday so that.
Sir, it will be listed tomorrow in another way.
Item 39.
Order they are till today, so for that I am pressing. Let it kindly be listed tomorrow.
This lordship religiously matter. So how can we pass any oppressive order? We don't touch the.
If we can pass an interim order, if I can, then I will dispose of the matter as well. Why I will recuse?
Because of your lordship is recusing. So status quo to
Kindly understand, sir, what is the purpose of recusal? Once it is recused, we will not pass any oppressive order.
because all these transactions are illegal. And the collector says so. So, Lordship, I understand your Lordship's predicament.
Please,
But my predicament is status quo is
folded
there.
hand, with my folded hand request, please go and read that NJC judgment on recusal. What it contemplates. I think all the 4 judges have given a separate.
Yes. May I pray one thing?
Please tomorrow when is say the matter would be listed in another way. Why you are?
Yes, yes.
I have read up.
39.
Pertinent similar matters of the same time.
What do you say?
Yes, number. Item 40.
Item 40.
Item 40, sir.
25, your lordships. Paragraph
For whom?
yes, your lordships.
You are a
ଆପଣ
peer.
ଯେଉଁ ବ୍ୟକ୍ତିକୁ କଲ୍ କରୁଛନ୍ତି ସେ ତାର ଉତ୍ତର ଦେଉନାହାନ୍ତି।
Your lordships, para 3.
Who is the peering for the response?
Even of India, your lordships.
My lord, we have appeared, even though they didn't have any locus standi, they filed the writ petition because the matter is related to the national emblem. That's why we filed the affidavit. We have taken all effective steps. There no need to continue this writ petition, my lord.
Your lordships kindly
A PI allegation filed, and they are alleging that even including the judiciary, everybody is misutilizing the same. We'll find out, we'll inspected the same. Some found, some admittedly, some mistake has been found out. Accordingly, we have taken steps, everything is rectified. And the state has given power, authority, and issue has, just a minute, just wait. Just wait.
Please try to appreciate it. He says that whatever you have flagged an issue, they have gone into, they found there are certain irregularities somewhere, and they say that they have already rectified it.
Your lordships, therefore, I say, your lordships kindly have a glance of the paragraph 3 of the order dated 12-3.
Please, he has said after that I have already
Your
done
lordship
it.
not rectified. I am also verified of that. I am also verified. Not rectify your lordships. Your lordships, they said that the Panchayat office Ganjams, it utilized the state emblem, your lordships. It is the clearly said in the 2007 rules, your lordships, 10.2, the Panchayat cannot utilize it. And in rule 8, your lordships specify that who is the utilized? The state emblem of India. Cannot, your lordships. Kindly have a glance of the rule 8 of the I file as the lordships details rules in additional affidavit, your lordships, which is a flag 1, your lordships. Page 22, your lordships, of additional affidavit. Rule 8. Display on the public buildings. Here is the categorically said where it is to be
Have you
displayed.
filed your affidavit, Mr. Paring?
Your lordships,
Yes, my lord. That's why. Let me complete, my lord.
I have perused the order of 26th of March.
Yes. Basing on that, we file additional affidavit, my lord.
File your affidavit.
This, we have filed an affidavit reflecting therein that lordship may see the page 5. Then
Where
what
is
action we have
the
taken, that
where
is
the
rectified, that
affidavit
was
you filed
given.
in terms of this order of 26.3? Where is the affidavit?
Yes. That affidavit has not been filed.
So that you took
Only we have filed an affidavit reflecting therein that as per the direction of the Honorable Court, we have issued a letter to the state government, the Chief Home Department, Home Secretary has issued a letter to Chief Secretaries, and if any discrepancy is there, they have to take necessary action by the state. And whatever mistake is found out by the petitioner, anybody is given to us. We have taken all steps in this regard. Now it is stake with the state to take necessary action, basing on the circular issued by the Ministry of Home, that is my lord. That is issued on 17th April 2025.
Yes.
That is issued by the Director Public, Ministry of Home Department on 17th April 2025.
Which one? Where from you are reading? No, Mr. DSG, I think there is some issues which in our opinion attracts a very attention of the citizen of the country. So
Yes,
let us fix a date, and it would be desirable if you can argue on that day.
Yes, my lord, yes.
So-
I'm always, man, yes.
So please tell us a date, we'll fix it here out, and please
My lord,
do one thing.
next
Please
week,
do one thing, I'm telling you. Not in that particular truncated manner this argument is to be. You'll have to bring that emblem act, the rules, the government, the GOs which are issued or the circulars which are issued by the central government from time to time about the use and the manner of use of the national emblem, and the persons who are entitled to use that national emblem. All these things must be brought, because
In the record, man.
look into those aspects. We cannot leave it in a just something is put in the air and then decide the things. Cannot be done. So when we can fix the date?
After vacation, anything.
Any day you suggest. Any day suggest.
After vacation, it may be
23rd June.
on 20.
23rd June, man. I guess.
23rd
June.
June. Come ready with
23rd June is Monday, my lord. If
Yes.
lordship will take in Wednesday, they can
this.
25th.
Monday is still you will be fresh.
Yes, I mean, Monday, I didn't have any problem because it's a PIL matter of lordship taking Wednesday. That's why I am
There is
20.
there is no day assigned for that.
Then any day, my lord, 23rd,
Yes,
20, 24th,
23rd June. 23rd June.
23rd, 24th, any day.
Yes. How many is left?
6.
Spill over to tomorrow.
Passover item, lordship, that is tomorrow, lordship, because today my
One thing.
expiring my.
One thing. Tomorrow. It's the.
I pardon my lord. I pardon my lord. I'm in virtual mode, my lord.
Yes.
When I'm in virtual mode, item 45. Here, my lord, the state has taken time specifically for filing of the counter, but till it is not filed counter.
Yes, 45, who is appearing?
I am appealing.
You have not filed counter.
Filing with. Next week we'll be filing counter letter.
Yes, the list 45 in the
A
next.
date will kindly fixed. A date will kindly fixed.
On 7th.
A date will kindly fixed.
7th.
Next week.
हम
any
लोग आपको
date
jealous
there
कर
will
दियो,
be there.
set कर दिया.
41. I appeared for the part number 4, private opposition party, filed my counter affidavit today. Can we have it on Tuesday, subject to my learned friend for the petition, his convenience?
Monday, 10th be on
Monday,
Tuesday.
Can it be fresh admission? Because this matter was.
What is there? Fresh admission or ultimately we have to hear. Yes.
Then item 44.
Great, sir.
We have to file the counter affidavit and we have to file out rejoinder. The counter has not been filed.
Yes, who is appearing in 44?
That's it, I am appealing. That is that the counter is not required pursuant to the lordship judgment. So let it come tomorrow.
So it
The
will.
document date to the.
Right.
Next week you want? Next week it will.
Next
So interim order to continue.
No, then tomorrow you.
No, yes, come tomorrow, but I.
Let's come tomorrow. In interim order, we'll see to. Tomorrow. Don't worry. Yes.